Morning. Yes, any
Please,
mention?
Your Lordship. My Lord, regarding Part 2, item number 15, if this matter may be fixed for 28/10/2025.
15.
Yes, item number 15, Part 2, hearing list.
Okay. You are for the petitioner?
My Lord.
Heard learned counsel for the petitioner, learned counsel, such and such, who makes a mention for listing the matter when?
28.
On 28/10/2025. The learned. What about the respondents?
The PP is Miss Mary, if she has no objection.
Okay. It is submitted that the learned counsel for the respondent has been intimated about the same. Accordingly, prayers allowed list on 28/10. Yes.
Objection.
May I please, Your Lordship, in
Yes.
making a mention of Part 2, item number 1.
Part 2, item number 1.
Yes. Your Lordship, I am out of station, so if this matter can be posted after some, on another next week or any week.
Otherwise,
Not this week.
it's a
Yeah.
fixed matter. Otherwise,
Yes, yes. And the learned counsel for the petitioner appellants, they are trying to file the IA. I have received a copy of IA.
yes.
In the meantime, if I may be allowed to file an IA, small IA.
IA for?
There's some development, and in the last court, before Justice Michael, we have submitted that there's some prejudice against the appellant. The fact was that his counsel in the trial court, his father was one of the prosecution witnesses, that was not informed to him. So
you want to bring that to the notice of the
of the
court?
court, yes, and the court has allowed us to file the IA verbally.
Learned PP, Miss such and such, who submits that she has some difficulties today and accordingly prays for listing the matter next week.
Well, if we'll be allowed to file an IA, it will take some time, so 2 weeks.
2 weeks. List the matter after 2 weeks. Stop. Learned counsel for the appellant has also sought for time as he would like to file an IA bringing certain developments, bringing subsequent developments to the notice of the court, which has been already allowed by this court. Stop. Accordingly, the prayers are allowed. List after 2 weeks. Yes.
May I seek Your Lordship's indulgence
Yes.
in mentioning item 6 of part 2.
Okay.
My Lord, the counsel for the respondent number 1, Mr. A.R. Malhotra, is out of station. So if this matter may be listed after 2 weeks.
When do you want?
After 2 weeks.
After 2 weeks. Learned counsel, Ms. such and such, makes a mention on behalf of Mr. A.R. Malhotra, learned counsel for respondent number 1, who is stated to be out of station and accordingly prays for 2 weeks time. Stop.
My lord.
List after 2 weeks. Yes.
If similar order may be passed for item 7, 8, 9 and 10.
Item 7, same counsel.
Yes, ma'am.
7, 8, 9 and 10, same order. Okay, Mr. A.R. Malhotra. Yes.
For motion, item number 1.
May it please Your
Yes.
Lordship?
Yes.
Yes, this contempt case is filed against the respondents, my lord. The fact is that we are the employees under the central government who have been posted at the central government health scheme welfare center at Unico, my lord.
Just take me to the operative
Yes.
portion of the
At page number
petition.
19, my lord. Paragraph number 5 and 6.
Page 19. Paragraph 5 and 6.
Yes, my lord. If I may read.
Yes, please do.
Considering the above submissions, it only appears that the case of the instant petitioners is squarely covered by the judgment and order in the division bench of the court, passed in WPC number 7550 of 2023, Union of India and others versus Mohandas and others, which upheld the order dated 2/5/2023 passed by the Central Administrative Tribunal, Guwahati bench in OA number 231 of 2019, and also the judgment and order dated 25/3/2025 passed in the passed by the division bench of this court in WA number 90 of 2024, by which the judgment and order passed by this court on the 19/7/2023 in WPC number 14 of 2021 was upheld. Para number 6, in the result, the petitioners are found to be are found to be entitled to be granted their respective HRA on the basis of HRA calculated for Y cities, class cities in terms of the recommendation of the 7th Central Pay Commission, which was notified by Office Memorandum dated 7/7/2017. The respondent authorities shall therefore work out the amount entitled to each of the petitioners as expeditiously as possible and thereafter grant them the amount which is worked out without delay. The entire exercise to be carried out within the outer limit of 3 months from the date of receipt of a certified copy of this order. Thereafter, my lord, the certified copy of the said order was received on 11/4/2025 and was communicated to the respondents via registered postal stamp on 15/4/2025. 15/4/2025. Till date, the respondents have not complied with the orders passed by this honorable court, my lord.
Okay. The present application under Rule 9 of the Contempt of Court, under bracket, Guwahati High Court, close bracket, Rules 1977, read with Section 12 of the Contempt of Courts Act 1971, read with Article 215 of the Constitution of India, has been filed alleging willful and deliberate disobedience of the order dated 7/4/2025, passed by this court in WPC number 121 of 2023. Stop. Para. Heard Learned Counsel for the petitioner, Miss Valentina Laldin-Pui. Stop. It is seen that in the order dated 7/4/2025, this court had directed the respondents to grant the HRA calculated for Y class, Y in inverted, okay, for Y class cities in terms of the recommendation of the 7th Central Pay Commission, which was notified via Office Memorandum dated 7/7/2012 to the petitioners. Stop. The respondent authorities were directed to work out the amount entitled to each of the petitioners and thereafter grant them the amount within a period of 3 months from the date of the order. Stop. It is stated that a copy of the order of this court was served on the respondents via registered post letter dated 15/4.
Yes, my lord.
Dated 15/4/2025. Stop. However, till date, the respondents have failed to comply with the order, hence the present petition. Stop. Para. Issue notice returnable within 4 weeks. Stop. The Learned Counsel for the petitioner shall take steps for service upon the respondent number 1, 2, 3, and 4 by registered post with AD as well as usual process within 3 working days. Stop. Just after 4 weeks. Yes.
Item 2.
My lord, here is a very unfortunate incident wherein the respondent number 3, that is my sister-in-law, had filed an FIR against me alleging that I had committed forgery in the mutation process of one of the LSCs belonging to my late father-in-law, my lord. And if I may take your lordship to page 69, my lord.
But we find that expert opinion was also taken by the investigating agency.
Yes.
And it was found that it was forged. The
But
signatures.
my lord, as per the statement given to the police and police, my lord, all the mutation process was done by my deceased husband, my lord. And my lord, one of my grounds in this criminal petition is that, my lord, the FIR was purely filed on for harassment and to wreak personal vengeance upon me, my lord, since the civil dispute civil suit is
Civil
presently
suit is
pending
also
against
pending.
between the parties, my lord. So, my lord, there
Okay,
are
we'll
several.
see. issue notice. Otherwise, between family members, such things should not happen.
Yes, my lord.
The petitioner herein is aggrieved by the FIR which was filed by the respondent number 3 against the petitioner on 4/6/2024 on the allegation that the petitioner had committed an offence of forgery in the transfer/mutation of LSC number 58/2000, which was originally issued in the name of her deceased father-in-law, it should be.
Father-in-law.
Deceased father-in-law. Stop. A criminal case has thereafter been registered basing on the FIR under section 465 IPC, and the matter is pending disposal before the court of the learned CGM, Aizawl.
It's a Judicial Magistrate First Class 4, Aizawl. It has been endorsed to the JMFC 4, my lord.
Before the learned JMFC,
4.
Aizawl. For learned JMFC 4, Aizawl. Stop. The learned counsel for the petitioner, Mr. Sarin Such. Stop. It is the submission of the learned counsel for the petitioner that a civil suit is also pending regarding the same issue, being, what is the civil suit number?
It's a civil suit number 61 of 2023.
Being civil suit number 61 of 2023. Before which court?
It's before the Civil Judge Senior Division
Bef-
3.
Before the
Aizawl.
Civil Judge Senior Division 3, Aizawl. Stop. And the criminal proceedings are also arising out of the same matter, and therefore it is prayed that the impugned FIR as well as the subsequent criminal proceedings may be quashed and set aside, as as the criminal proceedings are arising out of the civil proceedings. And
If I may interject, my lord,
Yes.
it's not the same LSC, but my submission is that, my lord, after subsequent to the filing of the civil suit, my lord, this FIR has been filed, my lord.
civil
the-
suit was first filed, then
Yes.
only the
Yes,
criminal.
FIR. It's a separate LSC, but my submission is that, my lord, the FIR has been filed after the subsequent to the filing of the civil suit, and this has been filed only to wreak personal vengeance and for malified intention, my lord.
Okay, you
So
delete
there
that
are-
last portion, not same. You just say that the FIR dated 4/6/2024 was filed only after the civil suit was initiated, and therefore the said FIR is nothing but an attempt to seek vengeance on the petitioner and due to personal grudges. Stop. In view of the above submission, learned counsel for the petitioner has prayed for quashing and setting aside of the FIR dated 4/6/2024 and the consequent criminal proceedings before the also charge sheet has already been filed.
Yes.
FIR dated 4/6/2024, the charge sheet 186/2025 dated 18/7/2024, and the consequent criminal proceedings pending before the learned judicial magistrate first class 4, Aizawl. Stop. Under this application under section 528 of the BNSS. Stop. Issue notice to the respondent number 3. Is it 3?
3 is the
Yes,
complainant,
to the
madam.
respondent number 3. Issue notice returnable within 4 weeks. The learned PP, Ms. Such and Such, has accepted notice on behalf of respondent number 1 and 2, and hence no formal notice is called for. The petitioner shall take steps for notice on the respondent number 3 by registered post with AD as well as usual process within 3 working days. Stop.
My lord, I have a
Yes,
small interim
please.
prayer, my lord, if the,
You want the proceedings to be stayed?
yes, my lord, at least till the next returnable date, my lord. My
Yes,
prayer is in page
list-
14.
List after 4 weeks. Stop. In the interim, the proceedings of the criminal trial number 573/2025 before the learned JMFC 4 Aizawl shall remain stayed till the returnable date.
I'm deeply obliged.
Item 3.
Petitioners herein are the bona fide landowners within the area of Longklai district. And Lordship, the respondents have acquired our land as per the Mizoram Land Acquisition Act, that is 2016. And Lordship, in the preliminary notification dated 5 November 2019, that is Annexure 1, page 28. If your Lordship can come to the relevant portion, that is para number 8, page 29.
Yes.
It is clearly reflected that this notification will not stand in the way of the petitioners or cause any prejudice to them to make a further claim under the RFCTLARR 2013 Act, depending upon the outcome of the WA number 70 of 2018, appealed by the Government of Mizoram in Division Bench of Guwahati High Court, Guwahati. So, Lordship,
But if I remember correctly, this
Yes.
petition has already been disposed, isn't
Disposed
it?
of.
Writ appeal.
and then the
Yes, dismissed.
common judgment and order which was passed by the learned single judge
Yes.
was upheld by the Division Bench.
Yes.
And Lordship, if the Lordship can come to the impugned order, the impugned letter, we have approached the respondent for reassessment as per
2013.
Yes. And Lordship, we have filed a representation, and although a reply was not given to us on inquiring the status of our representation, this letter has been given to us. That is on page 165, Annexure 15.
Now, this is addressed to District Collector.
Yes, by the respondent number 2, that is Land Revenue and Settlement Department.
Yes, please read.
Yes. Sir, with reference to the subject cited above, I am directed to inform you that the 2013 Act was adopted by the government and notified by number so and so, dated 28/3/2025, with effect from dated 11/3/2025. In this regard, I am directed to inform you that draft award number 1 of 2020, construction of various bridges and the approach roads and land for establishment of platoon along Longklai Vidka Parka Road was already settled under the 2016 Act, and no direction of the court or judgment is received to reassess the compensation till date. Hence, no further action is necessary unless and until the state government is directed to do reassessment by this honorable court.
Why does the court have to give direction every
That's
time?
why we have approached this honorable court since we have no alternative.
Who's appearing for the respondents?
Your Lordship, I'm appearing
Yes,
in the
yes, yes.
Yeah.
The writ appeal order is already there. It is dismissed.
Yes,
So which
yes.
means all
And
other cases.
Several writ petitions has already been disposed of in line with that, the same issue also, Your Lordship.
Yes.
Page number 171, that is Annexure 17, Lordship, this honorable court has already passed in similarly situated case also, Lordship. Judgment and order dated 21/11/2024.
Page.
171. WPC 125 to 2021.
This bunch of petitions. Order dated 21/11/24.
And the relevant portion, the direction given by this honorable court can be seen from page 206.
206. I think similar direction can be given. Learned government advocate, yes.
Yes, Your Lordship, the
Or
preliminary.
you want notice to be issued?
The
matter can be disposed of at the motion stage also.
No, it depends whether the government advocate has any objections.
I don't have objection in the matter because the preliminary notification Paran 8 also makes it clear, states clearly that there will be no
Yes,
bar.
depends on the that it depends on the outcome.
Outcome of the writ petition.
Read
Just
appeal. So they will dispose it of them. Sorry. The present petition under Article 226 of the Constitution of India has been filed by the petitioners praying for appropriate directions to the respondents for reassessment of the acquisition of their land in favor of the present petitioners under the Land Acquisition Act of 2013 in light of the notification dated 7/8/2020 made by the Secretary to the Government of Mizoram Land Revenue and Settlement Department. Stop. The heard learned counsel for the petitioner, Ms. Such and Such. Stop. Also heard learned counsel, Ms. Such and Such for the state respondents, and also MS Such and Such for the
Respondent numbers 4, 6, 7, and 8.
4, 6, 7, and 8. No objection to
Yes,
dispose
madam.
it of? Stop. Para. The case of the respondent, the case of the petitioner is that they are bona fide landowners within the area of Lotlai district, LAWNGTLAI, Lotlai district of Mizoram. Stop. The respondent number 2, by a preliminary notification memo bearing number capital K dot 12011/16/2017 -REV dated 5th November 2019 notified under section 11 clause 1 of the Mizoram Land Acquisition, Resettlement and Rehabilitation Act of 2016, notifying that the land specified in the schedule was likely to be needed for the purpose of construction of bridges and approach roads. And thereafter, and in paragraph 8 of the said notification dated 5th November 2019, it was provided that the notification will not stand in the way of the petitioners or cause any prejudice to them to make further claim under the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. On the bracket you write here and after referred to as the Act of 2013, close brackets. Stop. Thereafter, the awarded compensation amount was duly dispersed to the petitioners. Stop. Para. This court in WPC 20 of 2014 by an order dated a coordinate bench of this court in WPC 20 of 2014 by judgment and order dated 15/11/2015 had held that the Act of 2016 was not applicable in the state of Mizoram and that the Act of 2013 would be applicable. Stop. Being aggrieved, the state respondents had approached the division bench of this court by filing writ appeal number 70 of 2018 and writ appeal 71 of 2018. Stop. The division bench of this court, vide judgment and order dated 30th October 2024, was pleased to dismiss the said appeals and observed that the Mizoram Land Acquisition Act is less beneficial to the citizens of the state of Mizoram and therefore is not in conformity with the provisions of Section 107 of the Act of 2013, thereby affirming the judgment and order of the learned single judge. Stop. Para. The learned counsel for the petitioner has also taken this court to the letter written by the Land Revenue Department to the District Collector of Lotlai District, Mizoram. Stop. It is stated in the said letter dated 28 April 2025 that the draft award number 1 of 2020 was already settled under the 2016 Act, and there is no direction of the court or judgment is received to reassess the compensation till date. And it was also stated that no further action is necessary unless and until the state government is directed to reassess the same by an order of the court. Stop. The petitioner, the learned counsel for the petitioner has also annexed a copy of the judgment of this court passed in WPC 26 of 2023 and other connected writ petitions, wherein the coordinate bench of this court by order dated 207 yes, 1 minute. By order dated 21/11/2024 had allowed the petitions on similar grounds as the writ appeal preferred by the state respondent had already been dismissed by the division bench. Stop. Para. At this juncture, the learned government advocate, Ms. Such and Such, and the learned CGC and Ms. Such and Such have also consented to the disposal of the present writ petition by passing similar order as the judgment and order of the division bench passed in WPC, the earlier ones, 70-71, have not been disputed by any of the parties. Stop. Para. Accordingly, upon perusal of the materials and record, the writ petition is disposed of at the motion stage with the following direction. Stop. Number 1. The writ petitioners shall submit their applications before the district collector, Lotlai, Mizoram, giving details about their land which was acquired for the aforementioned projects, and also specify the amount which they have already received. Stop. The district collector, upon receipt of such applications, shall undertake the exercise of reassessment of the compensation amount to be received by each of the petitioners by applying the provisions of the Act of 2013, inclusive of the solatium and interest, and also interest on delayed payment entitled to each of the landowners. The amount already received by the petitioners as compensation shall be deducted from the assessment. Stop. Such an exercise shall be undertaken by the collector within 3 months from the date of receipt of the application from the petitioners. Stop. Next, the collector shall prepare the assessment as per the Act of 2013 and thereafter obtain the approval of the competent authority in the state government and thereafter forward the same to the respondent number four and five. No, 4, 5.
4, 6, and 8.
4 to the respondent number 4, 6, and 8. Who, upon receipt of the assessment made by the district collector, shall make necessary sanctioned and deposit the same before the collector within 4 months from the date of receipt of the assessment. Stop. The amount shall then be dispersed to the petitioners as per their entitlements without delay. So with these directions, the writ petition is disposed of. No order is to post.
Formation. Item 4.
My lord,
Yes.
my senior Mr. A.R. Malhotra is out of station. And
Anyway,
the respondents are yet.
This was for what? Admission hearing?
My lord, I am for respondent number 1 and 2.
What about pleadings? Completed?
No, my lord, I am seeking some more time for filing my affidavit.
Okay, heard learned counsel for the petitioner, MS such and such. Stop. Also heard learned CGC, who prays for how much time?
3 weeks time maybe.
3 weeks time to file an affidavit in opposition on behalf of the respondent number 1 and 2.
Yes, my
On
lord.
behalf of the respondent number 1 and 2. Stop. Yes.
If I may, my lord,
Yes.
although we had received notice on behalf of the respondent number 3, my lord, respondent number 3 is the competent authority Kala, my lord.
Yes.
So they'll have to take fresh steps upon respondent number 3, my lord, because we do not represent Kala.
Oh. And what about 4? Oh, that is arbitrator.
4 is arbitrator, my lord.
Okay. You are government advocate?
Additional advocate general.
Okay. The learned advocate general, additional advocate general, Sri Sami Sach, has stated that the petitioner has to take fresh steps for notice upon the respondent number 3 as the respondent number 3, deputy commissioner. You cannot represent the deputy commissioner.
Kala, my lord. As per the Highways Act, the Kala is a central government appointee, my lord.
Acha, okay. That the deputy commissioner has been implemented in his capacity as the competent authority under what act? Railways Act. Under the Railways Act. Appointed the respondent, yes. Under the Railways Act of 1989. Stop. Accordingly, the learned counsel for the petitioner is directed to take fresh steps upon the respondent number 3. Stop. The list the matter after how much time you were saying? 3 weeks. 2 weeks, 3 weeks. List the matter after 3 weeks, within which time the learned counsel for the respondent number 1 and learned CGC for respondent number 1 and 2 shall also file the required affidavit. List after 3 weeks. Yes.
Obliged.
Item 5.
For respondent number 1 and 2, I'm seeking 3 weeks' time for filing my appeal.
Learned counsel for the petitioner is present. Stop. Learned counsel, learned CGC prays for 3 weeks' time to file a counter affidavit on behalf of the respondents number 1 and 2. Here also, I think same, yes. Here also, they say that the deputy commissioner has been implemented as respondent number 3 in his capacity as the competent authority under the Railways Act 1989, and therefore the petitioner is directed to take fresh steps for notice upon the respondent number 3. Stop list after 3 weeks.
Item 6.
My lord, similar prayer for respondent number 1 and 2.
Here also same order, okay. Here also deputy commissioner. Yes, here also same. After 3 weeks.
Item 7.
May it please, Your Lordship.
Yes.
My Lord, as per office note dated 16/10/2025, AD card is still awaited in respect of respondent number 4 and 5.
4 and
We are taking
5.
fresh steps.
Learned counsel for the petitioner, Mr. Sanis is present. Stop. The notice, the return of AD cards from respondent number 4 and 5 is still awaited. Stop. Acha, what is this in respect of respondent to court's order dated 12/6?
Yes, Your Lordship, on 12/6/2025, I had made a submission before this honorable court that number 1 is that this respondent number 2, when the matter was pending before the trial court, he was a resident of Aizawl. He had taken one premises on rent. So after filing of this case, we found out that he has moved out of Mizoram and has somewhere in Guwahati. This information we obtained from the respondent number 1.
Oh,
But subsequently, we came to learn that he is arrested in Arunachal and is being lodged in the central jail in Itanagar.
acha, acha.
But we couldn't get any further information. In fact, this information regarding his arrest in Itanagar came by by chance. We have personally visited that address also,
Okay.
the Aizawl address.
Then can this petition proceed in his absence?
I believe so, Your Lordship, because the limited prayer in this appeal is that there was an agreement between the parties for execution of certain work. And in that particular agreement, it was mentioned that if there is any dispute arising out of the agreement, the civil courts in Guwahati will have jurisdiction. But the parties are from Aizawl. Cause of action arose in Aizawl. So that's why whether such order can be passed in violation of Section 17 of the CPC.
Acha.
That is the only issue. So even if this appeal is allowed, my lord, the matter will have to be remanded.
Yes, yes. Okay, what did we say? Return of AD cards from respondent number 4 and 5 still awaited. So accordingly, list after 2 weeks,
My lord.
awaiting service report on respondent number 4 and 5.
Obliged.
Item 8.
Your Lordship, in this matter, TCR has been received and paper book may not be required for disposal of this CRP. However, Your Lordship, looking at the trial court's record, page 1 to 38 is the order sheets of the learned trial court. This is what we need by both the councils for disposal of the matter.
Then we'll give a direction to give you photocopies.
Yes, photocopies of the order sheets. That is page 1 to 38 of the table of content is made by the registry.
Page
1 to 38.
1 to 38.
That is all what we need, my lord.
Okay.
So it may be furnished
Order
to us.
sheets.
Order sheets of
Order
the Learned
sheets.
Trial Court. So it may be taken up again after 2 weeks, my lord.
Yes.
Learned
Learned counsel for the petitioner, Sri such and such. So, the trial court records of civil suit number 81 of 2019 has been received by the registry. Stop. The learned counsel for the petitioner submits that the paper book may not be required, but the copies of order sheets from page 1 to 38 may be served on the counsels for the parties to hear the matter. Stop. Accordingly, the registry is directed to furnish copies of page number 1 to 38 of the order sheet of the learned trial court record to the learned counsels for the parties within a period of 1 week from today, and thereafter list this matter when? After 2 weeks?
After 2 weeks, ma'am.
List this matter after 2 weeks.
Much obliged.
You give the name of the respondent, also learned counsel for respondent such and such.
Item 9.
It appears that Your Lordship, none has appeared for the respondent. Actually, this case is very, very small, Your Lordship, very simple.
So respondent yet to file his objection. They have entered appearance,
They have
isn't
entered
it?
appearance, their names are reflected in the cause list.
Yes. Can we list it again next week? Let's see.
My humble prayer is that if the matter can be taken up on Thursday if possible, because the issue is very, very small, Your Lordship.
Thursday is a holiday, I think.
Oh, is it? I apologize. Very well.
Next week.
Next week. I'll inform the respondent.
Yes.
If we can have fixed dates so that I can inform them accordingly. Lordship.
28, 27, 28, anything?
Very well, Your Lordship.
27 is Monday.
My lord.
Lord learned counsel for the petitioner, such and such. The counsel for the sole respondent is not present. They have not filed the objection also,
Also.
and no objection has also been filed. Stop. List the matter on 27. List the matter again on 27th.
Deeply obliged.
Item 10.
Lordship, I'm seeking 1 week time to file amendment application.
Yes.
The necessary document which will recently acquired.
It's coming up for the first time.
No, my lord, there was an IA which was allowed, my lord, delayed.
Okay. So it can be admitted.
But yet there's yet to serve as a copy of the RFA also.
You serve them during the course of the day. Stop. This is an appeal under Section 17, Clause 2 of the Mizoram Civil Courts Act 2005, read with Order 41 of the CPC, against the judgment and order dated 4/10/2024, passed by the Civil Judge, Senior Division 2, Aizawl District, in Civil Suit 38 of 2018. Stop. Para. Her learned counsel for the appellant, Sri Such. Stop. The respondent number 2, 3, all the respondents, I think.
Yes, my lord.
All the respondents are represented by the Additional Advocate General.
No,
And-
one for,
And
Private respondent.
one is private respondent.
State is 2 to 6 months.
which one? You are respondent 4.
2 to 6 is state.
Okay,
respondent
2 to
number
6
1
for
is
additional
private.
AG, and then respondent number 1 is the represented by such and such. Stop. The appeal is admitted. Stop. Call for the trial court records from the Court of Civil Justice Senior Division 2, Aizawl District. Stop. The petitioner, the appellant shall supply copies of the appeal memo on the counsels for the respondents during the course of the day and list after 3 weeks.
Item 11.
My Lord, I have received the advance copy of the affidavit in opposition filed by the state.
Okay.
I don't know whether it's in the court copy.
Affidavit of R1 to 6.
1 to 6.
Yes, yes, it is here.
Yes.
Would you like to file any reply?
I would like to file my reply, my Lord.
The affidavit in opposition in respect of the state respondents number 1 to 6 has been filed, and the learned counsel for the petitioner, Mr. Lalfakswala, submits that he would like to file a reply to the same, and accordingly prays for how much time? 2 weeks.
2 weeks.
And accordingly prays for 2 weeks time. Stop. List after 2 weeks.
My Lord, there's a status quo.
The status quo order passed earlier shall continue till the next date.
Obliged.
Item 12.
Your Lordship, this is an impleadment application, whereas the respondent number 4 in the content case has been transferred, my lord, and a new incumbent has taken over the post, my lord. And this is an impleadment application for impleading the said new incumbent to the post of the Secretary to the MORTA, Ministry of Road Transport and Highways, Government of India, as respondent number 7 in the contempt petition, my lord.
The present application under Order 1, Rule 10, read with Section 151 CPC, has been filed by the petitioner, praying for impleadment of the new incumbent Shri V. Uma Shankar, Secretary to the Ministry of Road Transport and Highways, Government of India, as respondent number 7. Stop. Heard learned counsel for the petitioner, Ms. such and such. It is stated that the applicants / petitioners had filed contempt case number 12, contempt petition number 12/2024 before this court, alleging willful disobedience of the order dated 18/1/2024 passed by this court in WPC number 1 of 2024. Stop. It is submitted that during the pendency of the said contempt case number 12 of 2024, the previous incumbent had been transferred out, and Shri V. Uma Shankar has taken over the post of Secretary to the Ministry of Road Transport and Highways, Government of India. Stop. Para. In view of the above development, it is stated that it has become necessary to implead Shri V. Uma Shankar as respondent number 7 in the connected contempt petition 12 of 2024. Stop. Hence the present petition. Stop. Para. The court has considered the prayer of the petitioner / applicant, and it is seen that since a new incumbent has taken over as Secretary to the Ministry of Road Transport and Highways, Government of India, the prayer has become necessary to prayer has become necessary. Stop. Accordingly, the prayer is allowed, and the the petitioner applicant is allowed to implead Shri V. Uma Shankar as respondent number 7 in the contempt case number 12 of 2024. Stop. The petitioner shall accordingly file an amended cause title and take necessary steps for service on the newly implemented respondent number 7 by registered post with AD as well as usual process. List the matter after 3 weeks. Yes.
I'm appearing for respondent number 3. And
3.
Respondent number 3.
Okay. Learned counsel, Sir and such, appears for respondent number 3. And have you filed your affidavit?
Not yet.
Not yet. Learned counsel for respondent number 3 also prays for some time to file the affidavit. They accordingly list the matter after 3 weeks. So within that time you can file.
Oblige.
For orders, item 13.
May please, Your Lordship.
Yes.
My Lord, it appears from the office note that scanned copies of the TCR and the CD has been received. So if we may proceed with the hearing of the instant case.
Who's appearing, government?
Miss Mary, through VC, my Lord.
Oh, okay.
I am appearing, Your Lordship.
Okay.
My Lord, I was arrested on 26, 2025 for an alleged possession of 14 grams of heroin. I was accordingly booked under Section 21B of the NDNPS Act. Charge sheet has been submitted on 19/8/2025. I have submitted my bail application before the Honorable Trial Court, but the same was
Your date of arrest?
26/25.
26, 2025.
Charge sheet was submitted on 19/8/2025.
2025.
And I have submitted my bail application before the trial court, and the same was rejected on 15/9/25. And this is the first time I have submitted my bail application before this honorable court. So far, as of dates, I have been incarcerated for more than 4 months. My Lord, before submitting the grounds of this bail application, I will very briefly state the facts of the instant case.
Okay.
On this said date, on 26, 2025, an alleged amount of 14 grams of heroin was recovered partly from my right pocket pants and partly from the steel almirah inside my room, as per the case of the prosecution. And after that, I have been remaining in custody ever since. If I may take you to the information report typed.
This is 2021B, intermediate quantity.
Yes, my lord, intermediate quantity.
Yes.
The report of seizure and arrest, that is in page number 30.
30.
30, my lord.
Yes.
If I may read, my lord. To the officer in charge, ANS, Anti-Narcotics Squad, Excise and Narcotics Department, Aizawl, subject to report of seizure and arrest. Sir, I humbly bring to your kind notice that on 20 June 2025, I received the reliable information from my source, namely JA, stating that Van Raulu Apautu, which is me, from Chan Mari, used to possess heroin. I, along with my team, plan to conduct a search on the residence of the suspected person. On reaching the reported place, I recorded my grounds of belief, and in the presence of civilian witnesses, we conducted a search on the residence of Van Raulu Apautu. Van Raulu Apautu produced the suspected heroin, which he kept in a sting bottle and 4 tic-tac containers. He produced 1 tic-tac container from the right pocket of his pants, and he produced the rest from the steel almirah locker inside his bedroom. At 4:40 p.m. of 20 June 2025, in the presence of witnesses, I seized the recovered heroin, and it altogether weighed 14 grams. I also arrested Van Raulu Apautu, age 27, son of Val Malsong Apautu, from Chan Mari, Section 1, Chaltang Road, for possession of the said seized articles. I informed intimation of arrest to a relative of the accused, and grounds of arrest was explained to him. I therefore kindly request you to register a case against the accused under the appropriate section of law. Now proceeding with the grounds, my lord. My first ground is that since I have been charged under Section 21B of the NDNPS Act, which is an intermediate quantity, the rigors of Section 37 of the NDNPS Act does not apply here. Section 37 of the NDNPS Act says, 1, public prosecutor has to be given the opportunity, and 2, there has to be a reasonable apprehension that I am innocent. So since Section 37 does not apply here, we have to be governed by two principles of bail jurisprudence. The first principle is that whether my judicial custody is necessary, whether the same is necessary, and two, whether it fulfills the criteria laid down by the Honorable Supreme Court in P. Chidambaram's case. In P. Chidambaram's case, my lord, 5 factors have been laid down. The first factor is severity of punishment in case of conviction. In 21B's case, there is no minimum punishment. It simply says, which may extend to 10 years. And the second test...
Yes, learned PP.
Yes.
Charge sheet is already submitted. Investigation is over. Yes, so with stringent conditions, we can release him, I think.
Yes, Fellowship, stringent condition may be imposed. But and on the technical ground, I can argue because everything is complied with.
Yes.
But given
No, we will not go into that. Yes, we will not go into that.
Yeah. Given the fact that he's a student.
Only given the fact that the investigation is concluded, charge sheet is already submitted.
Yes, my lord.
Yes.
Stop. Heard learned counsel for the petitioner, Sri such and such. Stop. The case of the petitioner is that he was arrested on 26/2025 in connection with NTPS case number 156 of 2025, and he has been booked under Section 21 Clause B, small b, of NDNPS Act 1985. Stop. The submission of the learned counsel is that the accused has now been incarcerated for more than
4 months, my lord.
More than 4 months, and at this stage, the investigation has already been completed, and the charge sheet has been submitted on 19/8/2025. Stop. And the matter is now pending trial before the which court? Before the Special Court NDNPS Act 1985, Aizawl, Mizoram. Stop. The learned counsel for the petitioner submits that he had submitted a bail application before the Special Court NDNPS Act 1985, Aizawl, being bail application number 320 of 2025, but the same was rejected by the order dated 15/9/2025. Stop. Actually, let me just see the order of the trial court, on what ground it was rejected. Next,
Page number 57, my lord. The operative portion is on para number 4. Peruse the application as well as the record and consider the submission by both counsels. It is seen that 1 Tic Tac container of heroin was recovered from the immediate possession of the accused applicant that led to another 2 Tic Tac containers and 1 sting containers containing heroin from the locker of his almirah kept inside his bedroom. The case of the accused was opened this day and charge against him was considered, and the accused pleaded not guilty and claimed trial. The education...
but this was before filing of charge sheet, isn't it? You had filed...
After the filing of the charge sheet, my lord, yes.
Which was rejected by order dated 15/9/2025. No? Stop. Another ground taken by the counsel for the petitioner is that the petitioner has been booked for possession of intermediate quantity, and therefore the rigors of Section 37 of the NDNPS Act will not apply in his case. Stop. It is also submitted that the accused is you are a resident of Aizawl?
Yes, my lord.
Is a resident of Aizawl. Is a resident of Chanmari, Aizawl.
Yes, Chanmari, Aizawl.
Mizoram, and therefore there is no likelihood of him absconding or jumping bail if the prayer is allowed. Stop. Accordingly, learned counsel for the petitioner prays that the accused may be granted bail at this stage on any terms and conditions as imposed by this court. Stop. Para. I have also heard learned PP, Miss Mary, and such, and peruse the records available before the court. Stop. This court has also observed that the charge sheet has already been filed by the investigating agency on 19/8/2025, and accordingly the investigation process is now complete and the matter is awaiting trial before the special court in the NPS Act ISO. Stop. This court has also observed that the petitioner has been booked under Section 21B NDNPS Act, which is for possession of intermediate quantity. Stop. And accordingly, the records of Section 37 NDNPS Act are not applicable in the present case. Stop. The present petition is therefore allowed, and the petitioner / accused is released on bail on the following condition, under the following conditions. Stop. Number 1, execution of bail bond of rupees 30,000 with one surety of like amount to the satisfaction of the learned trial court. Number 2, the petitioner / accused shall appear before the trial court on every occasion as and when summoned without fail. Stop. Number 3, the accused shall not leave the jurisdiction of the trial court without the permission of the court concerned. Stop. With these directions and conditions, the petition stands dismissed.
I'm deeply obliged, my lord.
Item 14.
Your Lordship, I'm appearing on behalf of my senior, Mr. Lalviek Nungarnam, who is having personal difficulty today. I kindly request the matter will be released after 2 weeks.
Objections on respondents.
The IA is for delay, my lord.
Delay.
Yes, my lord. 406 days, my lord.
Objections also filed.
Objection is also filed, my lord. So the matter can come up after 2 weeks, my lord,
Okay.
for admission.
Learned counsel for the petitioner, Mr. Sergeant Search is present. Stop. Learned counsel, Sri Sergeant Search appearing on behalf of the leading counsel. Your senior's name? Leading
Mr. Lalviek
counsel.
Nungarnam.
Mr. Sergeant Search, please, for 2 weeks' time, as the leading counsel has some difficulties today. Stop. Accordingly, list after 2 weeks for hearing.
Similar player to
On the
item
IA, okay?
15
On
and
the IA
16.
117. Yes?
Similar order can be passed for 15 and 16 as well, my lord.
15 and 16.
Yes, my lord.
Okay, both IAs.
IA,
All
delay.
IAs, yes, in the IAs in 15 and 16, same order. Okay?
Item 17.
My lord, this bail petition is filed under section 483 of the NSS 2023, read with section 37 of NDNPS to enlarge the petitioner on bail in connection with custom case number 1 CL NDNPS Act.
Acha, 1 minute, okay? Just a minute. According to this, there is a notification, okay, the court which says that it should be listed before the same judge. So even if we were out of station, we used to take up through BC. So earlier it had come up before Justice Silo. Do you have this copy with you, this notification 27? there is a notification of the Guwahati High Court which says that in bail matters, if it has come before a particular judge, a subsequent application should also come up before the same court.
Yes, madam.
So even in my case, some cases which I had done in Itanagar, I used to handle through VC from Kohima bench. It used to be listed before me every time.
My lord,
So, yes.
I have approached to the register. Register has said we will make arrangement. And we have been waiting and waiting, and finally only today, after almost 3 weeks. And from the roster, the LAMS, previously bail order was passed by Justice Nelson Silo.
That's why.
And in the present roster, till today, he will not be coming back.
No, through VC.
I have requested the register. But till today, they are not making arrangement, and they are saying we will inform to you and we will send you the link. I have been waiting for almost 3 weeks, and finally today they have listed. And the petitioner is more than 3 to 4 years in judicial custody.
Let me just clarify. We'll list it again. If it's not possible, we'll list it again on Friday.
Yes, ma'am.
Okay.
My lord, in the meantime, we may be allowed to file a written objection.
No, that you can file. There's no bar. You are for?
I'm on behalf of my senior, Mr. Johnny L. Dautong, counsel for the respondent.
Which respondent? Respondent number? The sole respondent?
Yes, my lord.
Okay. Learned counsel for the petitioner, Mr. Sanjay is present. Learned counsel, such and such, represents the sole respondent and has submitted on behalf of his senior to for some time to file his written objections. Stop. As per the notification number 27 of the Guwahati High Court, the bail petitions are to be listed before the same court who had earlier disposed of the bail application in respect of the same case arising from the same FIR. Stop. Accordingly, the registry is directed to clarify the matter and list the same accordingly. Stop. After the clarification, if it is found that the bail application can be listed before any other bench, the same may be listed on Friday, 24/10. Stop. In the meantime, the respondent is allowed to file the written objection. Yes.
That's all.
Item 18.
Lordship, my senior has some personal difficulty if the matter.
This one also same. Here also same order. But you delete that part about the filing of the written objection, because here there is no written objection.
Your Lordship, meanwhile, a scanned copy of LCR may be called for from the learned trial court, because I have gone through the petition and I have seen that the petitioner has been incarcerated for more than 2 years. So just to see what the status, to make it clear.
Okay. Also call for scanned copy of the trial court records from the court of which court? Special judge.
Special judge, yes.
From the court of the special judge, NDNPS Act, Aizol.
Yes, my lord.
Yes, Aizol.
I'm deeply obliged.
Yes.
Item 19.
1 minute, okay. All bill petitions are raising the same right. Yes.
My lord, I have not yet received the paper book for the MIC.
This is coming up for the first time?
Yes.
Oh, okay.
Yes, Your Lordship, I believe that TCR has received.
No,
but
earlier appeal was admitted. Appeal was
Paper book-
admitted. Yes.
Paper book has to be prepared.
Oh, yes. Trial court records received. Trial court records have come.
Received, I guess.
Oh, yes, it has come. Learned counsel for the learned amicus for the accused, Miss Emily L. Kangte, and the learned PP, Miss such and such, are present.
Additional PP, Your Lordship. Additional.
Additional, okay, yes, additional PP, such and such are present. Stop. The trial court records have been received, and accordingly the registry is directed to prepare the paper book. Stop. This is the matter after the preparation of paper book.
Obliged.
Item 20.
May it please Your Lordship, I will be appearing on behalf of respondent number 3, which is UCO Bank, Aizawl branch, and I have just received my Vakalatnama from the branch today, so if I may be allowed, I will be submitting my power within the course of the day.
This IA is for
Continuation of
delay.
the day.
The learned counsel for the appellant is present. Appellant slash applicant is present. Stop. Learned counsel, Shri Such, submits that he has received instructions to appear on behalf of the respondent number 3 and prays for how much time?
If possible, 2 weeks.
Prays for 2 weeks time to file his Vaklatnama, as well as objections also,
Yes, ma'am.
as well as his objections to the IA. Stop. The prayer is allowed. List after 2 weeks.
Much obliged, ma'am.
18 days. 18 days. Delay.
Yeah.
Okay. 18 days. You want to object? Anyway. Yes.
Because I got instruction like to object. That's why.
Okay. It's fine. Yes.
Item 21.
This IA is filed for condonation of delay of 112 days.
Are you objecting?
Yes, my lord, we want to file our objection in this IA, my lord.
Learned counsel, Mr. Sanjay Pierce for the applicants. Stop. The learned counsel, Miss Such and Such, appears for respondent number 1.
Yes, my lord.
Respondent number 1, and the learned state, learned government advocate, Miss Your Caroline.
No, Your Worship, I'm appearing. This case is being handled by Miss Caroline, but she's on maternity leave.
Okay.
So I'm standing on her behalf, Your Lordship.
Learned government advocate and Miss Such and Such appears for the state respondent number 2. So, state is also filing objection.
No, Your Lordship.
Okay. Learned counsel for respondent number 1 submits that she would like to file an objection to the IA and therefore prays for
2 weeks time, my
2
lord,
weeks time
if permitted.
to file the same. Stop. Prayers allowed. List after 2 weeks.
Obliged.
Item 22.
This one fell off, huh? It's on the floor somewhere. You just pick it.
Yes, may it please your lordship, I'm here
Yes.
for the petitioner. And my lord, the AD card has returned and service is
Yes.
completed.
AD card in respect of sole respondent has returned. Learned counsel for the applicant slash appellant is present. No, petitioner for the petitioner slash applicant is present. Stop. The AD card in respect of sole respondent has returned on 14/10/2025 as per the office note. Stop. However, none appears for the respondent when the matter is called. Stop. Give them another chance. List the matter after 2 weeks, awaiting the appearance of the sole respondent.
Part 2, item number 2.
My lords, it is an RFA. The facts are very simple. And if your lordships indulges us today, my lords will finish it hopefully before lunch.
Okay.
My lords, I've made this brief note just so that your lordships has a very simple idea of the case. Your lordships refers to it. My lords, the plaintiff's case was for filing, my lords, basically, though he had a number of reliefs, the main thing was that this amount, 54,58,000, is due from, today I am the, my lords, appellant defendant in the suit.
Okay.
The suit was decreed in their favor.
In your favor. Oh.
Yes, my lords. And the suit, my lords, the consequential relief was that
Yes.
was that, my lords, this amount is due and payable by me, the defendant, to the plaintiff.
Okay.
Now,
This
my-
is regarding an award of contract.
Yes, my lords. Now, my lords, here I'll just take your lordships through through this small brief note. I am, my lords, I was the contractor. I was given 2 works by the PWD department.
Okay.
My lords, your lordship sees the first chart. There are 2 works, Girder Bridge, Aizol district, and there is one called Sazek Bridge in the next Mamit district.
Yes.
My lords, me and the plaintiff, we had an oral agreement. There is no written agreement, it's an admitted fact. The oral agreement was to the effect that he would come as a manager, work for me, and out of a particular, out of the amount worked by him, work executed by him, he would get his salary from there, 10%, which is the usual, my lords, rate of profit which contractors get, my lords. So, my lords, I am the contractor. I tell him, please manage, because I have workers coming from different states. I cannot converse in Hindi and Bengali. So, my lords, he is fluent. So, he manages the whole work site, though I am the contractor.
Okay.
Now, my lords, if your lordships comes to the second chart, Girder Bridge, my lords, this is the first work. Their case was, my lords, that the oral agreement I had with the plaintiff was that the amount of work to be executed was for 1 crore. Sorry, my lords.
Yes.
So, my lords, their case was, the plaintiff's case was that the first work would be executed for an amount of 1 crore 50 lakhs.
1 crore 50 lakhs.
We deny this. We see that it's much lesser amount, my lords. Insofar as the second bridge, second work site, nothing written. Insofar as the second work site, my lords, if your lordship sees the right column, the agreement which plaintiff's case was that the agreement was for that the works would be executed per kilo of steel used would be 150 kilos. This was their case. Lordships, my lords, in the last column, I hope this notice, my lords, puts the facts simply.
Yes, it's okay.
Yes, my lords. Now, my lords, what does he claim before the trial court? Plaintiff claimed, my lords, that rupees 1 crore 1,50,000 was paid to him. And my lords, this we do not deny. We paid him that much. But he says that since the work was 1 crore 50 lakhs, the remaining amount of 48 lakhs 50,000 is still due. Now this was their case, my lords. Insofar as the second worksite on the right column, they claim that they received 3 lakhs and a further amount of 6 lakhs 8,465 was due. Now if we add up my lords, these numbers, we get the amount starting at the beginning, which is 54 lakhs 58,465. This is the decree.
Okay.
Our only case today is, my lords, that he has not proved as to how this amount is due to him. Because, my lords, in an oral agreement, your lordships would know that the standard would be very high, because he would have to at least, in the minimum, bare minimum, prove the terms of the contract. So our only main point is today, my lords, when the trial court had decreed the suit in their favor, it was based on no evidence. No evidence.
And what about the PWs? Who were the PWs?
My lords, the plaintiff had also stood on the witness box. Apart from him, he had 2 employees of his own who had also deposed. But their evidence was nothing was led on this as to how this amount was due. I'll come to that, my lords. And insofar as our written statement, my lords, the stand of the defendants, we had justified the payments. We do not deny we made payments, that there was an oral agreement. All we are saying is that this further amount is not due.
According to you, this 48 lakhs something and then the 6 lakhs something, that is not due.
Not due at all. My lords, if it was, all he had to show, the plaintiff had to show, was that as per our agreement, you still have to pay this much. That term is not proved. That condition is not proved. So, my lords, I'll take your lordships through the paper book now. If I may take your lordships straight to the suit, which is at page, it starts from page 1. My lords, this is the suit filed by the other side, the plaintiff. Your lordship has it?
Yes.
My lords, if your lordship sees that very front in the middle, their prayer, my lords. A suit for passing a decree declaring that the defendant is liable to pay a total sum of rupees 54,58,465 only and other consequential reliefs. Your lordships has that.
Yes.
Now, my lords, I'll just, without going through each and every averment, because I know my learned friend would not object. What was the evidence put forth, my lords? Your lordships, at para 1, he says that he is a bona fide citizen. He says in the second line, he is the proprietor of MP Steel Fabrication, Peter Street, Khatla, and has been carrying business with well reputation for a period of about 15 years. And therefore, he has annexed certificate of registration, my lords. This is his first document.
Yes.
In the second, your lordships, I'll just take your lordships straight to what was annexed. Photocopies of completion certificate dated so-and-so, dated and completion certificate dated so-and-so, issued by BGM Consortium Private Limited and Balaji Developers respectively. My lords, these completion certificates are not related to me. These are the works he had may have carried out with other contractors. Today, my lords, I am just making clear that I am Blue Hill Engineers. It's a proprietorship firm. From the cause list itself, my lords,
Blue
it's clear.
Hill Engineer, yes.
Now, my lords, so he has put, my lords, first of all, the certificate of registration and completion certificates of other works. Now, my lords, if I may take your lordships to para 4. Your lordships has it?
Para 4, yes.
If I may read. That the defendant was allotted a work for construction of girder bridge at Upper Khatla, which is now commonly known as Aizol Lake, for a total cost of 2 crores 22 lakhs. On such allotment, the defendant contacted several steel fabrications as he intended to engage them for carrying out the construction. However, they could not have settlement with regard to price or cost of the construction. On 18th March 2018, the defendant offered the said construction work to the plaintiff through phone call. and requested him to undertake the work and offered a sum of rupees 1 crore 40 lakhs only for the said construction. In response, the plaintiff told the defendant that rupees 1 crore 40 lakhs would be cheap for such huge construction and asked him to raise the sum. Thereafter, defendant offered another rupees 10 lakhs only for erection of work, which would make the total sum of rupees 1 crore 50 lakhs. The offer was thereafter accepted by the plaintiff and agreed to do construction of the said work for a total sum of rupees 1 crore 50 lakhs. The plaintiff without delay started construction in full swing on 11th April 2018 as there was extreme pressure from the public as well as concerned department, PWD, Government of Mizoram. As such, construction was carried on in day and night, and hence labor cost was also much higher than usual. In short, the plaintiff did his level best effort for speedy completion of the work in day and night, even though there was no written contract agreement made between the parties. However, existence of contract between the parties is very clear from the foregoing averments as well as enclosures to this plaint. Thereafter, my lords, he annexes photocopies of screenshots from WhatsApp conversation, trying to show that there was an agreement. Now, my lords, I have to just submit one thing here. My learned friend will also not object to this fact. The WhatsApp conversations do not say regarding the price of the works. It only shows that there was some communication with regards to the work, what was happening at the work site, what was the progress to date. That's it. Now, my lords, para 5, that the work was quite expensive and needed huge expenditures right from the beginning, and defendant had paid certain bill costs of the said work to the plaintiff in installments. My lords, can I just stop here? My lords, their case, our case was that I am the contractor. PWD gave me the contracts.
Contract.
I am supposed to work, I am working. I just needed somebody to manage the work site, the workers. So I employed him the plaintiff as a manager. So my lords, whatever payments which will now come, the 1 crore 1,50,000, that was for salaries of the employees. That was for the materials to be used at the work site. And out of that, my lords, out of that complete sum that I have given, 10% profit would be his salary. That was our case. So, my lords, I'll continue. However, the total sum paid to the plaintiff for the said construction was rupees 1 crore 1,50,000, leaving a balance of rupees 48,50,000. Payment for a sum of 90,000 was given in checks as shown below. My lords, these checks he has annexed. However, another sum, which is total rupees 11,50,000, was paid to the plaintiff herein through direct transfer to the bank account of plaintiff by the defendant. So, my lords, if 90 lakhs and 11,50,000, we come to the total of 1 crore 1,50,000. So, my lords, the checks he has annexed as in his documentary evidence. Para 6, that when 99.90% of the work was completed, the defendant without proper reason asked the plaintiff to leave the construction work and offered another work, that is Sazek Bridge. I know that is the second
one.
Yes, at Rajiv Nagar. Since the plaintiff was in good faith, he simply accepted the said offer and left construction of Girder Bridge at Upper Khatla. So he left the first work site, went to the second, started working. Voice record of conversation was, my lords, put in a compact disc as their thing, but nothing, there is nothing, no discussion about the rates of work. So, my lords, in para 7, your lordships, that the defendant again verbally agreed to do Sazek Bridge at Rajiv Nagar, Mamit district, Mizoram. It was verbally agreed by the parties that the said construction work was to be executed by the plaintiff with a rate of rupees 150 per kilo. My lords, these are bridge strengthening works, and the first one was, my lords, construction of a bridge itself. So, my lords, steel was used. So that per kilo refers to the steel. Now, my lords, I'll continue. Plaintiff had promptly started construction, but when 90% of the work was completed, severe flood struck them to finish the work and waited for certain time. The defendant had paid rupees 3 lakhs only by way of check bearing number so and so, dated so and so. However, the defendant, without proper reason, again asked the plaintiff to leave the said strengthening work making a balance of rupees 6,08,465. So my lords, we again put the check that we do not deny that we have paid them 3 lakhs at least. Para 8. From the facts and circumstances, it is clear that defendant without proper reasons terminated the verbal contract made with the plaintiff in 2 occasions as given above. Plaintiff suffering in both pecuniary and non-pecuniary losses severely affected his business. As such, defendant paid the agreed sum. That is, the total sum due to the defendant is 54,58,465. Your lordships may have para 9. Then my lords, we can go to the WS. That even after several requests and demands, the defendant did not pay heed and failed to compensate the loss suffered by the plaintiff. However, the defendant informed the plaintiff that he engaged him as work manager in such construction, denying their contract as given above. Because my lords, their case was that apart from the money, you had actually subcontracted the whole contracts and not merely employed.
Not just as a manager.
Yes, correct. So my lords, that's why. It is pertinent to mention herein that the plaintiff, who is well-reputed establishment, could in no way be engaged as a mere work manager for such single construction, as the plaintiff is in fact busy enough in his own establishment. But having heard the offer, he accepted the same in good faith as stated above. It is to be mentioned that if the offer was a mere manager, the plaintiff would certainly decline such offer from the very beginning. The plaintiff, through lawyer, served a legal notice dated so-and-so to the defendant, noticing to pay payment of rupees so-and-so within 1 week from the date of receipt of the notice. However, despite duly receipt of the notice, the defendant failed to pay the said amount. And my lords, the second last was this photocopy of legal notice, my lords. Thereafter, my lords, he had filed the civil suit. He had filed the first suit, my lords, para 13 if your lordships has. Plaintiff had filed civil suit number 46 of 19 against the defendant before the Senior Civil Judge 3, claiming the aforesaid sum and other consequential reliefs. But due to certain technical defects, plaintiff submitted an application for withdrawal of the suit. As such, the Senior Civil Judge 3, by his order dated 13th May 2020, disposed of the case on withdrawal. However, liberty was granted to the plaintiff hearing to file the case afresh, and hence this instant suit was filed. So, my lords, this was their case.
Okay.
Now, my lords, what have I said in my WS? Your lordships may have that. But before that, my lords, can I just take your lordships to the evidence lid?
Okay.
So that, my lords, your lordships, any queries that may come, your lordships can. Your lordships, from page 10.
Page 10.
Yes. Just for a wholesome, my lords, exercise. My lords, this is the certificate of registration of his proprietorship firm, MP Steel Fabrication. And thereafter, my lords, page 11 onwards, is the completion certificates which he had said he had worked with different contractors.
This doesn't concern you.
Doesn't concern me. Doesn't. Para page 13 onwards, your lordships would see. Specifically, page 13B, my lords. These are the WhatsApp chats. Quickly, I'm just taking your lordships through it. All the way till, my lords, page 15B. 13B to 15B, my lords. These are the WhatsApp chats. Again, these WhatsApp conversations do not say anything regarding dues, rate of work, terms of contract. Paras page 16, your lordships has, is the picture at the work sites. Your lordships have
16.
16A is a better copy.
1 minute. Yes, page
16A is the
16A
page
photographs.
Photographs.
Yes.
Your lordships may just have a look at the first photo at page 16A. Your lordships, the person who is standing there at the work site with his hand, my lords, pointing, that is the, my lords, appellant today. He was the defendant.
Okay.
All I wanted to show this, my lords, that if the work was totally subcontracted, I had no reason to be there at the work site. But nonetheless, my lords, the next pages are the checks by which I had made payments amounting to 1,150,000 And my lords, I'll stop there. I'll take your lordship straight to the written statement, which is at page 29. Your lordships.
Page 29, yes.
Page 29, my lords. My lords, we had denied all the averments made in the plaint, but I'll take your lordships through our main submissions, which starts at para 5. And I'll
Yes.
just I'll skip irrelevant paragraphs, but I'll take your lordships through para 5, sub para 2 onwards. That the defendant is the team leader of the Blue Hill Engineer, herein referred to as BHE, which is the appellant today.
Wait. Where are you reading?
Page 29.
Page 29.
Para 5, sub
Para 5, clause
2.
Sub para 2. Okay.
Sub-para.
Yes.
The defendant is the team leader of the Blue Hill Engineer. That the defendant is a renowned person, not only national but also contributed several research works in international level in the field of bridges and other civil engineering subjects. My lords, I'll leave it there. That is who I am. I'll come to my lords 4, sub-para 4. That the defendant needed a considerable number of different field assistants, which may be called as managers or interpreter, construction equipments and workers to execute the work. Next, that the defendant did not need any subcontractor to do his work, but he needed a manager who would collect some construction materials, seeking workers from outside of Mizoram and to interpret with the workers. Sub-para 6. Plaintiff is the proprietor of LP Steel Fabrication, the plaintiff, with work experience in small-scale steel fabrication, including roof trusses, grills, etc., and he has a working knowledge of Hindi and Bengali. That the defendant felt that the plaintiff could be best employed as a manager who would seek and search for laborers and workers from non-Mizos as well as Mizos, and that the defendant also felt that the plaintiff would be reliable to buy raw materials, some construction equipments, collect and mobilizing workers, and to do any other needful in the said work. So this was the purpose of his, my lord's, engagement with the plaintiff. That the plaintiff was not capable of being employed as a subcontractor, because a subcontractor has to have a proper knowledge regarding the work without any supervision of engineers or other experts. I'll stop here only, my lords. Then your lordships has at sub-para 9, my lords. The last.
Yes.
That it was offered that after the work was completed, 10% of the estimated amount would be considered as contractor profit of the work completed by the plaintiff would be his share. So my lords, out of the total monies that I give, say I give him 100, 10% which would be 10 rupees, that would be his profit. Now my lords, at the next page, page 31, is my averments on merits, my lords. My lords, your lordships has para 3, I'll start from.
Yes.
That the contents of para 4 of the plaint are false and strongly objected. That the work was allotted to the defendant and the plaintiff was merely employed to look after the construction. And from 11th April 2018 onwards, the construction began. It was offered and agreed between parties upon the following terms and figures. Now, my lords, this is the crux of the breakup as to why I have given the 1,150,000. A, my lords, total steel requirements for the bridge construction. My lords, this is the first work site. Is 141.90 ton. So my lords, this is the total. When I got the
This is for that girder bridge.
Girder bridge. So my lords, the steel and the whole construction, because it was made of steel, it has been, my lords, quantified at 141.90 ton, the total works. Out of this, my lords, your lordships have the clause 1 and 2. It has been bifurcated in this manner. Steel requirements of bridge, 83,464.340 kg. Stiffeners, additional gusset plates, etc. amounting to this much. The total in terms of tons is equal to 100.157 ton, my lords. Now in 2, you have the scaffolding and support, which amounts to 41.74 ton. Your lordships may just appreciate one thing here, my lords. If it was a subcontract, they would have at least averted this bifurcation. They would have been able to pinpoint that this much of ton would be needed for this whole construction if it was a subcontract. But there is no subcontract. That's why they have not made such an averment. I had to come and justify before the trial court, my lords, being the contractor. Now, my lords, this bifurcation is very important because, my lords, so the total works is for 141.90 ton. I had engaged the manager to manage the works up till, my lords, your lordships has 100.157 ton in clause 1 of the para 3.
Clause
Para 8,
1,
subpara.
para-
Yes.
Yes.
This much was for what I had sought his help for, my lords. Not 141. It was 100.157 ton. Now, my lords, in my pleadings, I have stated that if your lordships comes to sub-para B onwards, and if I may read, that the quoted.
Okay, so the entire work
Yes.
was, the estimate was 141.90 ton.
Yes. And my lords, in terms of money, in para B, we've said that the quoted rate of work was calculated in terms of ton, and that is rupees 1,04,997 per ton, and the whole work was estimated at 141.90 ton, which is worth of 1 crore 48 lakhs 99,074 rupees. So, my lords, this is the quantification in terms of money. See, my lords, if I'll read the sub-paras here onwards, that the plaintiff was employed and asked by the BHE to manage and complete the work only with his collected labourers and workers up to 100.157 ton, not 141, my lords. For the construction of the bridge only by using all the materials provided by the BHE, and the remaining 41.74 ton was the supporting materials belonging exclusively to the BHE. So, my lords, for 100.157, we are saying please manage. The rest we will do it by ourselves. You don't need to manage because this part we do not need extra labourers, whatever the reason may be. Now, my lords, the next few paragraphs are very relevant. That it was agreed that the plaintiff would use all the materials belonging to the BHE, that is the defendant, and their supplies for the construction of the bridge, and 10% of the estimated amount of the plaintiff's work would be his remuneration as work charged. So 10% would be his profit. My lords, at para E and F, my lords, that the plaintiff did not have any materials, steel, etc. on his own. He was employed merely as a manager to take over the construction. All the materials needed for the construction, including salaries of workers, were provided by the BHE in terms of money, and it was the duty of the plaintiff to buy and collect the materials and pay salaries to workers. That the BHE gave money to the plaintiff in check or bank account transfer anytime when materials for the purpose of the construction and salaries for labourers were needed. Your Lordships, I'll just stop here for a second. All the materials, all the salaries of the labourers, that was all borne by me, the contractor. And I had taken your lordships through one of the through the plaint of the plaintiff. He has also said himself there that he had paid certain bills. He admits that those monies came from him, it was used for that purpose. No, therefore, my lords, because he had said in his plaint that he incurred losses. If he had incurred losses, he would have shown that he had made payments for materials, for labourers. Nothing was there, my lords. Now, my lords, I'll just take lordships to this F and my lords para 4, and you can, my lords, close the written statement.
Yes.
My lords, sub-para 5. That with the BHE's money being spent by the plaintiff, the value of all the work completed by the plaintiff was calculated to be rupees 96 lakhs 39,774. That is 91.81 tons into rupees 1,04,997. We are saying, my lords, you've done works up till, you've managed works up till 91.81 tons. So this amount of steel quantity, we've duly calculated with the rate given by PWD, which is 1,04,997. And we arrive at a calculation of 96 lakhs 39,774.
That was the value of the work done by the plaintiff.
Done by the plaintiff.
96 lakhs 39,000.
Yes.
Okay, then.
And that the defendant had already paid the plaintiff exceedingly by paying rupees 1,50,000 in installments, and out of which 10% of the amount of work completed by the plaintiff would be his remuneration. Now I have to just clarify here, my lords, one thing. This 1,50,000 is not, my lords, just the work of the first work site. It includes the second work site also.
That's why I was wondering how it has come up to so much.
So the difference between the 96 lakhs and this 1 crore 1 lakh comes to about, my lords, around 5 lakhs 10,000. So this is not some excess amount. Of course, there are some, my lords, we do say it's excess, even in excess. But, my lords, it also includes the second work site. That's why we've come to this. Now, my lords, at para 4, that the contents of para 5 of the plain stated the right amount of money paid in installments by the defendant to the plaintiff, a sum total of rupees 1,50,000. It is pertinent to mention here that the plaintiff had not used any of his money in this construction, and all the money needed for the cost of the work was supplied by the defendant from time to time, because the plaintiff was merely entrusted and employed to manage the work. That the averment made by the plaintiff stating a balance of rupees 48,50,000 leaving behind by the defendant is strongly objected. That the plaintiff was not entitled to claim the remaining amount of money, that is rupees 48,50,000, because firstly it was the total amount of cost of supporting materials which belong solely to the BHE. And as per agreement, the plaintiff cannot claim more than 10% of the total amount of the work. Secondly, the amount was not included in the plaintiff's assigned work expenditures because the supporting materials belong to the BHE. Because your lordship saw that 100 ton was regarding the, we had said this was the steel requirement, stiffeners, additional gazette rates, etc. But the supporting work, scaffolding, which amounted to 41 tons, around 41 tons.
41.74.
That was totally our work. Now, my lords, I just want to, insofar as the second work site, we have stated that in para 6 of our written statement at page 33. I'll take your lordship straight there.
Para 6.
Para 6. I'll read, my lords.
Yes.
That the contents of para 7 of the plaint are wrong information and strongly objected. That the BHE had offered the plaintiff to manage and do the work of Sazek Bridge strengthening work at Rajiv Nagar, Mamit district, Mizoram, only if the plaintiff was willing to accept the rate of work offered by the BHE, that is rupees 80 per kilo of iron. This was our case. That the plaintiff said minus 150, we said 80. That was our agreement. Yes. Now I'll continue, my lord.
Yes.
80 kilos of iron. That the plaintiff did not make any acceptance to the rate of BHE. However, the plaintiff simply started the work without making any proper acceptance to the BHE's rate. That the BHE provided the materials for the work, and it was the job of the plaintiff to manage and do the work. Your lordships may kindly, my lords, come to the sentence which starts with "it is also pertinent to mention," which is, my lords, around 4 sentences down.
Yes, it is
also pertinent to mention here that the plaintiff was an employee and not a contractor. That the work was continued by some other agents. However, BHE carefully calculated the work which was already undertaken and finished by the plaintiff, including his small contributions of materials, and that it was estimated to be rupees 3 lakhs. That the BHE for the ends of justice paid the estimated amount of 3 lakhs to the plaintiff without delay, and thereafter it is strongly asserted that the BHE has no amount due to the plaintiff. So now, my lords, so far as the second bridge is concerned,
Okay, so that means the second work he did not complete.
none of them were complete, my lords. The other one, my lords, though he was employed for 100 ton, your lordships would recall, he had done 91.80 ton. Insofar as the second one also, there is no quantification of the works completed, first of all. He had to prove that case. But we are saying we had paid him 3 lakhs. So if your lordships adds 96 lakhs, odd lakhs with 3 lakhs, it comes to 99 lakhs. That extra amount of, say, about 2 lakhs, that we had paid him extra. Out of our own bona fides. So, my lords, this was the case before the trial court. I'll just take your lordships quickly through the, my lords, the examination in chief of the plaintiff is at page 38. That is his evidence before the court. Your lordships has page 38.
Yes.
My lords, here I will not take your lordships through the whole of the depositions, but I'll just take your lordships through certain. It's a reproduction of the plate itself. At page 39, para 8. Sorry.
39, yes.
Para 8 minutes. That the work was quite expensive and needed huge expenditures right from the beginning, and the defendant had paid certain bill costs of the said work to me in installments. My lords, this is the reason why we had paid him, to take care of the bills and costs of the works. So he admits, my lords. Your lordships come straight to para 9. That when 99.90% of the work was completed, referring to the first work site, the defendant without proper reason asked me to leave the construction work and offered another work, which is Sajak Bridge strengthening work at Rajiv Nagar. Since I was in good faith, I simply accepted the said offer and left construction of Girder Bridge. Now, my lords, is 99.90. There is no proof led. We say it's 91% if you calculate in terms of percentage. 91.80 tons was complete, so 91%. This 99.90 is without proof, totally baseless claim. Now, my lords, I'll take your lordships through para 10, 11 and 12 only, my lords. There are two parts of it. My lords, para 10, page 14.
10, yes.
Yes. That it was verbally agreed by us that the said construction work was to be executed by me with a rate of rupees 150 per kilo. I started construction without delay, but when 90% of the work was complete, severe flood struck us and waited for some time. The defendant paid rupees 3 lakhs. However, the defendant without proper reason again asked me to leave the said strengthening work, making a balance of rupees 6 lakhs 8,465 to be paid. Again, my lords, I just want to say that there is no proof regarding the that 150 rupees is the agreed rate of work, and that 90% was complete so far as the second work site. Now, my lords,
and what about this 6 lakhs 8,465? What is the basis?
My lords, that is our case. There is nothing. My lords, at para 11. That from the facts and circumstances, it is clear that the defendant without proper reasons terminated the verbal contract made between us in 2 occasions. So, my lords, he admits that both of them were verbal contracts. And he further says, my lords, I have suffered in both pecuniary and non-pecuniary losses which severely affected my business. Now, my lords, your lordships knows. Pleadings itself cannot, my lords, be the basis of a decree. there has to be some evidence that he suffered losses. He admits that I paid for all the construction materials, laborers, but there is nothing to show that he had made some payments. No evidence there. So I do not know how losses could have been claimed. And their case, lastly, at para 12 was defendant is in duty bound to pay the agreed sum, which is 54,58,465. Now, my lords, in his cross-examination starts from page 45. I just want to point out one thing here, my lords.
Yes.
Page 45. I just want to point at para 3, my lords. Para 2 and 3. It is a fact that we do not have any written agreement between I and the defendant. So that is, my lords, a fact which has been proved. Para 3. It is a fact that the defendant used to pay bill by way of installments, but denied the suggestion that the defendant fully paid the cost of work done by me. So, my lords, at one point he's saying you paid, at one part he's saying not fully paid. But that is another fact which he had to prove. Now, my lords, I'll leave it there. This was the evidence given by the plaintiff himself. His other two witnesses PW number 2 is at page 48. This is his own employee. Very short. Very short.
48. Yes.
My lords, if I may. Page 48. Para 2 onwards, I'll start.
Yes.
That I used to work in MP Steel Fabrication under the proprietor of Mr. Lanunthara. He is the plaintiff from 2014. I have been working in both Sazek Bridge and also Azor Lane. That Mr. Lanunthara employed me for the construction of Azor Lane, and we also received our salary from him, and there is no pending salary. Para 5. That during said construction of Azor Lane, we worked under the supervision of Mr. Lanunthara. However, when MP Steel Fabrication was terminated from said construction of Azor Lane, I also gave up the work of Azor Lane. As far as my knowledge is concerned, the total number of persons left the said construction was around 20% when MP Steel Fabrication left the site. That when we left the site, we almost completed the work and at least we finished 99.90% of the total works. That I also worked under Mr. Lanunthara for construction of Sazek Bridge, strengthening. After completion of around 90% of the work, we could not continue to work due to flood and we left the work. That the plaintiff herein has never worked as manager under Blue Hill Engineering. This was his own in chief. The very next page at page 50 is his cross. And I'll just point out two very relevant facts to you. Para 3. It is a fact that I do not know whether there was an agreement between the plaintiff and the defendant. So, my lords, he doesn't know if there was an agreement or not. If he did not know, proving the terms of an agreement would be, my lords, more or less impossible. Para 4. It is a fact that the construction of Azor Lane and Sazek strengthening works were Dr. Lal Khamona's work. My lords, is a very relevant fact.
That's the defendant.
That's the defendant. They themselves are saying this is my work. Therefore, my lords, he could not say that he is a subcontractor. But I'll come to that, my lords. Page 51 is the PW number 3. Again, my lords, it is the same.
Yes, this one also.
Same. He's an employee. He says more or less the same governance. And again makes the very same averment in his cross-examination. Page 53 at para 4. It is a fact that the construction of Azor Lake was Dr. Klamwana's work. He only says with regard to the first work site, but he admits. Yes. My lords, if I may just read parts of these paragraphs. In his cross-examination, the defendant stated in point number 3 that he does not remember the exact time when he started to engage the plaintiff and also does not remember the time when their engagement terminated. In point number 6, defendant admitted the suggestion that he and the plaintiff by way of telephone call discussed about construction work of Azor Lake before they physically met each other for the said work. My lords, your lordships, we stop here itself, and my lords, we can skip to para 28, my lords, because it's a reiteration of everything.
Okay, 28, yes.
On careful consideration of available evidences for both the parties, it is not disputed that the plaintiff had executed the construction works of Girder Bridge known as Azor Lake at Upper Khatla and Sazek Bridge strengthening works at Rajiv Nagar, to which defendant was the contractor for both construction works, and there is no written agreement between the parties. Your lordships. Para 29. As per the evidences of the plaintiff, he had executed the construction work as subcontractor under the defendant, which is verbally agreed upon by the parties through telephone calls. Corroborating this, the defendant admitted the suggestion in point number 6 of his cross-examination that he and the plaintiff by way of telephone call discussed about construction work of Azor Lake before they physically met each other. Further, the defendant admitted in point number 7 that he never used the term manager to the plaintiff at a time when construction of Azor Lake was about to carry on. This is in the considered of the opinion of this court, plaintiff was not engaged as a manager. I have to stop here, Your Lordships. If Your Lordships saw at para 29, the 4th line, which starts with corroborating this. This is wrong, my lords. Because what was, if we read para 29 again, as per the evidence of the plaintiff, he had executed the construction work as subcontractor under the defendant, which is verbally agreed upon by the parties through telephone calls. Corroborating this, I have not corroborated this, my lords. The defendant admitted the suggestion in point number 6 of his cross-examination. Your lordships may just kindly have my cross, what I have admitted or denied. This is that page, my lords. Page 57. Your lordships has it?
Page 57, yes. The cross of the defendant.
Yes. I may just read point number 6.
Page 57. Yes.
I admit the suggestion, point number 6. I admit the suggestion that I and the plaintiff by way of phone discussed about construction work of Azor Lake before we physically met each other for the said work. Now I'll take your lordship straight back to para 77, page 77, page para 31. Now, my lords, para 31 reads, on the basis of Exhibit P9, check number so and so was issued by the defendant in favor of the plaintiff for withdrawal of rupees 30 lakhs on 8th April 2018, which is after the telephonic conversation of the plaintiff and the defendant and 3 days prior to the execution of construction work by the plaintiff. Further, on the basis of Exhibit P10, 11, 12, these are all the checks. It is evident that the defendant issued check number so and so for rupees 40 lakhs, check number so and so. These are the, so the court, trial court observes that payments were made. On the basis of exhibits, as stated above, a number of checks were issued in large amount of money for execution of the construction works. In the meantime, there is no evidence on record for both the parties regarding the salary of the plaintiff in daily or monthly basis as a manager under the contractor, that is the defendant. This is in the considered opinion of the court another indication that the plaintiff was not engaged as a manager. Lords, this is an assumption. How you can call him anything. In fact, my Lords, let us call him a subcontractor also. Ultimately, my Lords, the relief of 54 lakhs has to be on some credible evidence. These are, my Lords, the minor issues. So, my Lords, the concluding part of this issue is at para 33. Therefore, on the basis of available evidences on records with facts and circumstances of the case as stated above, this court is of the considered opinion that the plaintiff was not engaged as a work manager, but he was working as a subcontractor under the defendant, and the present issue is decided in favor of the plaintiff and against him. Now, that's again, this has no basis. Actually, you cannot call him a manager also, let us say. I cannot call him a manager, but does that automatically mean that I can call him a subcontractor? No basis. My Lords, para 34 is the issue number 3. It starts, but I again take your Lordship straight to the relevant portion of this discussion insofar as this issue. Premature termination.
Issue 3.
Yes. Whether the work of subcontractor was prematurely terminated. Para 37. On the basis of evidences, Para 37.
Para 37. Yes.
On the basis of evidence adduced by both the parties, it is evident that after verbal agreement, the plaintiff started the construction of Azon Lane on 11th April 2018, and as there was extreme pressure from the public and concerned department, the work was carried on in day and night. That as per the evidences of the plaintiff, when 99.90% of the work was completed, the defendant without proper reason asked him to leave the construction of Azon Bridge work and offered another work, that is Sazak Bridge at Rajiv Nagar. It is further evident that when the construction of Azon Bridge was completed, there are 5 head mistries along with a number of daily labourers, and Mr. Zakir Hussain was one of the 5 mistries employed in the bridge construction, and he was an alcoholic and often caused trouble to his fellow workers and also used to misbehave to the plaintiff family. And hence Zakir Hussain was finally terminated for the work of Azon Bridge. My Lords, Mr. Zakir, whether he was an alcoholic, not relevant. These were put in his in-chief examination by him, but it has no relevance. Para 38 is the concluding, my Lords, finding. That after termination of Mr. Zakir Hussain, the defendant offered the Sazak Bridge strengthening work to the plaintiff, and after verbal agreement, the plaintiff executed the Sazak strengthening work. But when 90% of the work was completed, severe floods struck them and waited for some time. However, the defendant, without proper reason, again ordered the plaintiff to leave the bridge strengthening work. Therefore, the evidence of the defendant that the plaintiff became dishonest and incapable to continue the work, and the immediate cause arose when the plaintiff had ill-treated one of the 5 witnesses, Mr. Zakir Hussain, is ruled out on the ground that after termination of the said Zakir Hussain and completion of 99.90% of Azon Lane, defendant had offered another work, that is Sazak Bridge strengthening works, to the plaintiff, and the present issue is decided in a positive in favor of the plaintiff. My Lords, can I just have to clarify, your Lordships? Your Lordships may not be confused in case your Lordships.
What is this Zakir Hussain got to do with the termination?
My Lords, what their case was. Mr. Zakir Hussain was my mystery. He's the head mystery, he's the seal fabricator. Apparently, he was an alcoholic. He had some issues with the plaintiff, my Lords, at the work site. He had caused some trouble, as per them. Today, he has passed away, but they had even initiated some criminal proceedings. Beyond that, there is nothing relevant so as to decide the issue based on Mr. Zakir Hussain. He is totally alien to this issue. How does a mystery, an employee, have anything to do with premature termination? All you had to show us, my Lords, as a plaintiff, that there was a term, that there was a condition in our agreement that if I did this, that would be premature termination. Nothing. I'll finish up with this issue number 4, my Lords. This is the main one. Your Lordships may come to, my Lords, if I may just read this entire discussion.
Issue 4.
4. This is the effective relief For determination of the present issue, plaintiff stated that on 18th March 2018, the defendant contacted the plaintiff and offered the said construction work through telephone call and offered rupees 1,40,000 only for the construction work. That the plaintiff asked the defendant to increase a bit more, and thereafter the defendant offered another rupees 10 lakhs, which would make the total sum of rupees 1 crore 50 lakhs only, which is accepted by the plaintiff. That as per exhibits P9, 10, 11 and 12, the total amount of money paid by the defendant to the plaintiff for construction of Girder Bridge, Azor Leh, was given in check in 4 installments amounting to rupees 90 lakhs. Another 11 lakhs 50,000 was given through direct transfer to his bank account, and the total amount paid to the plaintiff is rupees 1 crore 1 lakh 50,000. With regards to the Sazek Bridge strengthening work, the plaintiff further adduced that as per the verbal agreement between the parties, he had executed the work at the rate of rupees 150 per kilo and completed 90% of the work when the severe flood struck them, to which the defendant paid rupees 3 lakhs by way of check, and the remaining balance is rupees 6 lakhs 8,456, the remaining. Although the defendant denied almost all the plaintiff case, he has corroborated the total amount of payment he has made and stated in para number 7 of his evidences that with BHE's money being spent by the plaintiff, the value of all the work completed by the plaintiff was calculated to be rupees 96 lakhs 39,774, that is 91.81 ton multiplied by rupees 1,04,997, and that he has already given the plaintiff exceedingly an amount of rupees 1 crore 1,50,000 in installments, and out of that amount 10% of the amount of work completed by the plaintiff would be his salary. In point number 26 of his cross-examination, the defendant denied the suggestion that while contacting the plaintiff, he proposed to the work for rupees 1 crore 40 lakhs, and also denied the suggestion that while contacting the plaintiff, he proposed to the work for rupees 1 crore 40 lakhs. Also denied the suggestion that he accepted to give a bonus of rupees 10 lakhs. In point number 27, he has liabilities amounting to rupees 48.5 lakhs to the plaintiff for Azor Leh and rupees 6 lakhs 8,465. Your Lordships, can I just clarify this? This is totally contrary to the record. If your Lordships has page 58. Yes, ma'am. Point 27, bottom. I deny the suggestion I have liabilities. The trial court somehow said as if I have accepted the liabilities. So based on this, decided the issue. Based on this only, this issue is decided. Para 45 is the concluding. Therefore, on the basis of the above discussion with findings in 4 foregoing paragraphs, this court is the considered opinion that both the parties made verbal agreement for execution of Girder Bridge for a sum of rupees 1 crore 50 lakhs, only out of which defendant paid 1 crore 1 lakh 50,000, with the remaining balance of rupees 48 lakhs 50,000. Further, that there is also agreement for Sazek Bridge strengthening works at the rate of rupees 150 per kilo, in which the defendant paid rupees 3 lakhs only with the remaining balance of rupees 6 lakhs 8,465. Hence, the total amount of money payable by the defendant to the plaintiff for construction of Girder Bridge and Sazek Bridge at para 46 is rupees 54,58,465. And thereafter, my lords, at page 86 is the decree, but I would not take the Lordships. Effective was that paid within 3 months. At page 86. And also directed me to pay 10,000 as costs. My lords,
Yes.
Today our only case is that if your Lordships has the Evidence Act, court must be finding
Evidence Act.
just 2 sections I want to show your Lordships. lords may have section 101. This act. Burden of proof. Your lordships has it.
Yes.
Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. When a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. It's a very general proposition. That burden, according to us, never shifted. Or should I say burden was never discharged. Section 102, on whom does the burden lie? The burden of proof in a suit or proceedings lies on that person who would fail if no evidence at all were given on either side. So my lords, even I admit that I have justified the amount, but there is no countering evidence as such, because it is a verbal agreement. Ultimately, that burden was on the plaintiff, which he has not discharged. This is plainly our case today. Therefore, my lords, without any evidence, how should the trial court without any evidence, without the plaintiff discharging his burden, decree the suit? Now, my lords, I've just made a small compilation of judgments. I'll end with this, my lords. My lords, this is 2018 4 GFT 733, Renu Shri Lakkar. There it was regarding partition deed, whether it was forged or not, regarding a immovable property. But I'll just read through these relevant paragraphs.
Yes.
What therefore follows from the above authorities is that when both parties adduce evidence in support of their respective issues and the entire evidence relating to the facts in issue are before the court, burden of proof loses its importance and the question of burden of proof becomes merely academic. What is important to note is that evidence must be adduced in respect of the issue involved. Mere examining of some witnesses by both the parties or adducing some evidence not relevant to prove the real issue in controversy, or when such evidence adduced by the parties are not sufficient to arrive at a satisfactory conclusion, without further evidence, relevancy of burden of proof does not disappear. Therefore, when each party adduces evidence to prove and disprove the fact in issue, then only the importance of burden of proof disappears. There is no gainsaying the initial burden is on the shoulder of the plaintiff who knocks the door of the court for a decree or relief in his favor asserting certain facts, being the sole basis of the claim, be it negative or positive, to prove such facts. Unless the plaintiff discharges his burden, he cannot succeed in the suit despite weakness of the defense case. Apparently, in the case at hand, plaintiff brought the suit for declaration that the alleged deed of partition was forged, and therefore initial burden was on the plaintiff to prove the plea of forgery. If the plaintiff adduces some evidence in discharge of his burden, the onus may stand shifted to the defendant to rebut such evidence. Therefore, unless evidence is brought on record, enabling the court to come to a conclusion on the facts in issue, the question of burden of proof remains relevant. Now, my lords, your lordships may have the third citation, Anil Rishi versus Gurbaksh. Pleading is not evidence, far less proof. Issues are raised. I'm sorry, madam. Pleading is not evidence, far less proof. Issues are raised on the basis of pleadings. Defendant appellant having not admitted or acknowledged the fiduciary relationship between the parties, indisputably the relationship between the parties itself would be an issue. The suit will fail if both parties do not adduce any evidence in view of Section 102 of the Evidence Act. Thus, ordinarily, the burden of proof would be on the party who asserts the affirmative of the issue, and it rests after evidence is gone into upon the party against whom at the time the question arises, judgment would be given if no further evidence were to be adduced by either side. And lastly, my lords, if your lordships has the next citation, Adiveppa versus Bhimappa. This was again property dispute, my lords, regarding partition deed and my lords.
This regarding initial burden.
Yes, my lords. It is settled principle of law that initial burden is always on the plaintiff to prove his case by proper pleadings and adequate evidence in support of the law. I would not take your lordships through the other citations, same point of law. So today, my lords,
Yes.
leaving aside whether he's a manager or subcontractor, how does he, is there any evidence on record to show that that amount is due? That only he has to satisfy me. We are saying that
Yes.
May it please your lordship.
Yes.
As my learned friend already thought in details about the story, I'm not going.
Yeah, don't go to the facts now.
Lordship, yes. However, lordship, I must say that this judgment and order is not liable to be interfered. And for that, your lordship, first of all, I must say that one of the core issues involved in this appeal is calculation of the quantum of amount, the quality of the amount. Means, my learned friend said, we already paid in full, but I said it was not paid. So for that, your lordship, the thing which I would like to take your lordship kind of attention is that this is civil case, not a criminal case. Proof beyond benefit of doubt is not required in a civil case. And the trial court already rightly held, more specifically at page number 82, your lordship, page number 82, that it quoted one citation, one judgment. Page number 82, may I take you at page number 82, lordship?
Yes, yes, that we have seen.
Yes.
We've already seen. But there's nothing, absolutely nothing. What did you place before the court as evidence? At least there has to be something beside your own statement.
Lordship.
Your deposition, that's all.
Lordship, lordship. I'll
What
come
is
to
there?
that point, your lordship.
What is there? Yes.
So, first, as the learned trial court
And
referred
being
this
the
judgment.
plaintiff, being the plaintiff.
Being a plaintiff, I
yes,
must prove,
the
your lordship.
burden is on you. Yes.
Exactly, your lordship. Burden is upon me. So, your lordship, for that, in this judgment and order also, it says preponderance of probability of the case is enough.
Fine.
It says, yes. So, in that, your lordship, I must say that in my examination in chief, which is found at page number 38, lordship, page number 38. Actually, I did not have any material evidence like documentary evidence. I did not have documentary evidence regarding that contractual agreement. But I have oral agreement, I have oral evidence here in lordship. And in this page number 38, lordship, I'm skipping some portion. However, let me jump to paragraph 4 of my exam in chief.
Paragraph 4.
Paragraph 4, lordship. May I read, lordship? That in the year 2007 and 8, I worked with BGM Consortium Private Limited having its main office at Kolkata. I work for all iron structure and other steel works at Aizawl, and completion certificate date so and so, showing my performance was issued. Again in so and so, I work all the iron steel structure, roofing sheet, chain link, fencing, and SS railing works in construction of sports stadium at Zotlang Champai, under Messrs. Balaji Developers having its main office at Ghaziabad, UP, for which completion certificate date so and so was issued with outstanding credit. The reason why I'm just mentioning is that I have outstanding performance in steelworks from long time ago. So in this construction of girder bridge also requires expertise in steel construction, as almost all the construction work was using steel materials, not other wooden or not other cement. It's almost all the parts are steel materials, Your Lordship. And Lordship, this appellant, in fact, was a newly constituted firm, having no proper workers that time, Your Lordship. And as my performance in such steel works was outstanding, he contacted me by telephone and negotiated about the price, the amount, for which, Your Lordship, 150 was suggested. And for that, Your Lordship, there was a proof of 150. 150 means the work was agreed to be done for a sum of rupees 1,50,00,000, Your Lordship. And that was specified in the following paragraph, para number 6. I'm reading, Lordship, para number 6. Maybe only para number 6 and 7 only, Lordship. That the defendant, when he was allotted said construction, contacted several steel fabrications, as he intended to engage them for carrying out the construction and more particular steel works. On 18/3/2018, the defendant offered the said construction work to me through phone call and requested me to undertake the work and offer me a sum of rupees 1,40,40 lakhs only for the said construction. In response, I told the defendant that 1.4 crore would be cheap for such huge construction and asked him to increase a bit more. Thereafter, the defendant offered another rupees 10 lakhs only for erection of work, which would make a total sum of rupees 1.5 crore. Only thereafter, I accepted the offer and agreed to do construction of the said work for a total sum of rupees 1.5 crore. I'm stopping here, Your Lordship. As per my version, there was no written agreement, as already agreed with my learned friend. However, there was an agreement between the parties for undertaking the construction work for a sum of rupees 1.5 crore. So, Your Lordship, in that point, let me just jump to the page number 45, I'm sorry, Lordship. 45 is, Your Lordship, the cross-examination. May I read, Your Lordship?
Yes.
This is only 2 pages, only 7 paras. Number 1, it is a fact that I understand the examination in chief submitted by me. Number 2, it is a fact that we do not have any written agreement between I and the defendant. Number 3, it is a fact that the defendant used to pay bill by way of installment, but denied the assertion that the defendant fully paid the cost of work done by me. Number 4, it is a fact that on 17 November 2018, I was expelled from the work. Number 5, it is a fact that Mr. Zakir Hussain was one of the 5 head mystery, and the relation between him and I was not good. Number 6, it is a fact that we did not have a written agreement in Sajak Bridge strengthening work at Rajiv Nagar also. Number 7, it is a fact that I did not complete the Sajak Bridge strengthening work at Rajiv Nagar, but I claim that I had completed 90% of the work. So the reason why I'm reading out the cross-examination is, Your Lordship, there's no effective cross-examination as to the amount. In my examination, it is clearly stated that there was agreement between the parties and 99% of the work was completed, and the amount offered after tables of negotiation was 1.5 crore, Your Lordship. So there's no effective cross-examination in the particular point, Your Lordship. As per the decision of the higher courts, if there's no effective cross-examination on what had been stated in the examination in chief, it is presumed to be admitted, Your Lordship. And the next thing is that, Your Lordship, page number 48, Your Lordship. Page number 48.
PW2.
This is PW2. Who is PW2, Your Lordship? Para 2. That I used to work in MP Steel Fabrication, Khatla, Pete Street, under the proprietor of Mr. Laluntara Mapuya, he is the respondent herein, from 2014. Number 3, that I have been working in both Sajak Bridge strengthening, Rajiv Nagar, and also Aizol Lay Bridge Upper Khatla. He was the one who actually put hands on such two construction, Your Lordship. So he is vital witness. Number 4, Mr. Laluntara employed me for the construction of Aizole, and we also receive our salary from him when there is no pending salary. Number 5, that during said construction of Aizole, we work under the supervision of Mr. Laluntara Mapuya. However, when MP Steel Fabrication was terminated from the said construction of Aizole, I also gave up the work of Aizole. And as far as my knowledge is concerned, the total number of persons left the said construction was around 20 persons when MP Steel Fabrication left the site. And number 6, that when we left the site, we almost completed the work and at least we finished 99.90% of the total works. Number 7, that I was also work under Mr. Laluntara for construction of Sajak Bridge strengthening. After completion of around 90% of the work, we could not continue to work due to flood and we left the work. Number 8, that the plaintiff herein has never worked as manager under Blue Hill Engineering. He never worked as a manager. And, Lordship, the relevant portion again is page number 50. There is no effective cross-examination again as to the percentage of completion and as to whether he is a manager or interpreter, Your Lordship. There is no effective cross-examination on that point. And number 1, Your Lordship, page number 50. It is a fact that I know the Blue Hill engineer and its team leader, Dr. R. Lalthamwana. Number 2, it is a fact that I know about the incident case and I understand the content of my examination in chief. Number 3, it is a fact that I do not know whether there was an agreement between the plaintiff, Laluntara, and the defendant, the Blue Hill engineer. Number 4, it is a fact that the construction of Aizole and Sajak Bridge strengthening were Dr. Lalthamwana's work. It is a fact that I am not deposing falsely. So, Lordship, the crucial point was not cross-examined and it was kept intact, Your Lordship. And again, Your Lordship, page number 51. This is the last witness. The plaintiff, last witness, page number 51. I'm not reading in whole, but he is the one who actually put his hands on the construction of Aizol Lake.
He
The
also
first
said
construction.
almost same thing. as
Almost same,
PW2.
almost same, yes. Exactly, Lordship. But he did not undertook the work in the second construction, Your Lordship. Only the first construction, Your Lordship. So, Your Lordship, in this cross-examination also, I'm not reading in whole, that's given in page number 53. The crucial point was kept intact, Your Lordship. It was a cross-examine. And again, Your Lordship, regarding the allegation, regarding the submissions of my learned friend, with regard to the quantity of work, the quantity, the amount which is to be entitled by the plaintiff. I must say that, Your Lordship, some of the submissions are in fact beyond the pleadings, beyond the evidences, actually. However, Your Lordship, I must say that, Lordship, in the DE, defense evidence, at page number 55, page number 55, as everything was based on the evidence, let me just skip the pleadings, but I'm just jumping to the evidence portion.
Is the
55.
Examination in chief of
appellant.
Of the appellant.
Lordship. Para 5, Lordship. This is crucial point, Your Lordship. That from 11/4/2018 onwards, the construction began and the whole work was estimated at 141.90 ton, which was worth an amount of rupees 1,48 lakhs so and so, that the plaintiff was employed and asked by the BHE to manage and oversee the work only up to 100.157 ton, which is his collected laborers, and workers for the construction of the bridge, and only by using all the materials provided by the BHE. The remaining 41.74 ton was the supporting materials belonging exclusively to the BHE. Number 6, Lordship, that the plaintiff, I'm reading only 6 and 7 only, that the plaintiff did not contribute any material. All the materials needed for the construction, including salaries of workers, were provided by the BHE in terms of the money. That the BHE gave money to the plaintiff in check and by bank account transfer anytime when any materials for the purpose of construction and salaries for laborers were needed. Number 7, that with the BHE's money being spent by the plaintiff, the value of all the work completed by the plaintiff was calculated to be 96 lakhs so and so, and that I have already given the plaintiff exceedingly an amount of rupees 1,50,000 in installment, and out of which 10% of the amount of work completed by the plaintiff would be his salary. Lordship, what I would like to summarize in this particular evidence is that this particular piece of evidence is in fact collaborated with the plaintiff evidence. Why? Lordship, the appellant herein as a defendant stated that in para number 5, the total, the whole work was estimated to be 141.90 ton, which worth an amount of rupees 1,48 lakhs. It's almost 1,50, the agreed price, Lordship. It almost reached. And Your Lordship, in that point, I must say that at the time when negotiations started, it was offered rupees 1,40 lakhs.
1,50 lakhs.
Yes,
according
1.4
to you.
crore. Yes. But after several talks, after the second talks, it was agreed to rupees 1.5. And the thing which is to be kept in mind is that, Your Lordship, the total construction work, the work amount, was a total of rupees 222 crore and 22 lakhs, Your Lordship. 2 crores and 22 lakhs. That's given in my pleadings, not denied by the defendant in each written statement. 2.22.
2.22, the total amount of the contract.
2.22, Lordship. So, meaning that, Your Lordship, if 1.50 crore was paid to me, as I undertook all the field works, he still has a benefit of 72 lakhs, Your Lordship. 72 lakhs, still. So, Your Lordship, in that point, the negotiation, the agreed terms, 1.5 crore was quite reasonable in comparing with what had been actually sanctioned for the construction, Your Lordship. And, Your Lordship, now the appellant herein claimed that I was paid in excess, Lordship. As per the version of the defendant, which I have read through, the total value of work I undertook was 96 lakhs something.
39,000.
Yes, 39,774. But they paid me 1 crore.01. And it is exceeded by, Lordship, it is exceeded by 5,10,225. 5,10,225. It was exceeded. However, Lordship, in the whole proceedings, in the whole pleadings, there's no counterclaim. Or even prior to this case, there's no claim, maybe by way of criminal or civil, or maybe by way of legal notice, a claim back of rupees 5 lakh was not happened, Your Lordship. That clearly shows that, Your Lordship, they make...
No, they said that was adjusted against the other work.
Yes, Your Lordship. But I admitted the fact that, but Your Lordship, that adjustment itself is also what I said, that's beyond what has been seen in the evidence, Your Lordship. That's not clarified at all, Your Lordship. So that's the only first thing which, the first time I happened to be known from the appellant, Your Lordship, that adjustment, Your Lordship. And for that second work, I received 3 lakhs. I'm not denying that fact, but it's quite separate, Your Lordship. And Your Lordship, another thing is that the particular evidence, the witnesses which come on behalf of the respondent, the appellant are, one is the worker, one is his wife, Your Lordship. For that, Your Lordship, may I kindly take you at page number 59. Page number 59. I'm reading, Your Lordship.
Yes.
Under 3 para. That I was a worker at the work of the bridge construction, Aizawl. There was no written contract between the plaintiff and the BHA. That's undisputed fact. The plaintiff was an employee of the defendant in the work. That's also not in disputed fact. Not in dispute means I was under the appellant. Number 2, that the BHA had no intention of executing any written contract with any agent to be a subcontractor. The defendant was the contractor and there was no other subcontractor. That as far as my knowledge is concerned, the BHA did not cause any pecuniary or non-pecuniary losses of the plaintiff. Meaning that, Your Lordship, he is such a big construction agent, construction company, let me say, as of now. But on this January 2024, his turn comes and the only witnesses which he produced is this person, Your Lordship. Who is this, Your Lordship? The next page, Your Lordship, page number 60. Number 1, I'm reading it whole, Your Lordship. I do not remember the year I joined the Blue Hill Engineer, but I am still working there. In the January 2024, he is still in the BHA. Number 2, I work in Blue Hill Engineer, dealing with measurement of the materials. And it is correct to suggest that I work as helper. Number 3, Lordship, I do not remember the year when construction of Aizawl was commenced, and also do not remember the year when it was completed. He don't even know. Number 4, I work as helper. He was a helper during construction of Aizawl. Number 5, during said construction, I stayed in a construction near the work site. He stayed in a site constructed near the work site. Next, I admit the assertion that I have no personal knowledge of the communication, if any, made between the plaintiff and the defendant. Number 7, I admit the assertion that I came to know the absence of written contract between the parties from the defendant. Next, I admit the assertion that I came to know the statement the plaintiff was an employee of the defendant in the work from the defendant. Number 9, I admit the assertion that statement made at para 2 of my examination in chief is made known to me by the defendant. Number 10, I have no personal contact with the plaintiff. Number 11, I have never visited the plaintiff's workshop at Khadla, that is the main workplace of the respondent. Number 12, I admit the assertion that I have no discussion made with the defendant with regard to work relationship between the parties. Number 13, I have no knowledge about laws which may be caused upon the plaintiff except what have been told to me by the defendant. It is a fact that I am deposing falsely today. So that's all, Your Lordship, the cross-examination. Meaning that all the knowledges were earned from the appellant himself. not any single independent information. And page number 61, Lordship. 61 is DW3.
DW3, DW2, DW3.
Each
Wife of the appellant.
Yes, Lordship. Each only relevant para is only 4 paras I'm reading, Lordship. Number 1, I'm the wife of Arnold Thamwana, the defendant in the suit, that there was no written contract between the plaintiff and Arnold Thamwana, and no amount of money is recoverable by the plaintiff from my husband. He was the contractor in the work and he did not have any subcontractor. The plaintiff was merely employed by the BHA, that he was found to be disloyal to the work at the later stage, so he was dismissed from the work. However, the Blue Hill engineer has no amounts due payable to him. Number 2, that the nature of works involves high-skill engineering technique and different simultaneous tasks to perform. That the workers and the major part of the construction materials had to be collected from outside of Mizoram. That the BHE needed a considerable number of different field assistants, construction equipments and workers to execute the work. The BHE did not need any subcontractor but needed an employee who would collect some construction materials, seeking workers from outside of Mizoram and to interpret with the workers. Number 3, that the plaintiff had a work experience in steel fabrication. Yes, he also admitted that fact. And he also had a working knowledge of Hindi and Bengali. Therefore, he would be reliable to buy raw materials, construction equipments, collect and mobilizing workers, and to do any other needful in the said work. The BHE had no intention of executing any contract with any agent to be a subcontractor. It was decided that the BHE would employ the plaintiff as an employee who would collect some construction materials, seeking workers from outside of Mizoram and to interpret with the workers. Number 4, that all the materials needed for the construction, including the salaries of the workers, were provided by the BHE in terms of money. That the BHE gave money to the plaintiff in check and by bank account transfer any time when any material for the purpose of the construction and salaries for laborers were needed. They agreed that 10% of the amount of work completed by the plaintiff was his salary. Now, Lordship, the cross-examination is quite relevant, Lordship. Page number 63. Number 1, I got married with the defendant so-and-so on 25/5/2018. Number 2, I do not know the time when construction of Aizawl Lake commenced. Number 3, I know that the construction commenced prior to getting married with so-and-so. Number 4, it is a fact that the plaintiff and the defendant started to communicate with each other with regard to the aforesaid work prior to I got married with the defendant. As such, some portion of the terms of work between them is known from my husband, and some other portion is also known from my personal knowledge, as the work was continuous in progress even after I got married the defendant. Number 5, that the plaintiff was given a sum of money by way of cash, bank transfer and check by the defendant. I also personally handed over the said sum of money to the plaintiff in some occasion, and I mostly transferred by way of bank transfer as far as I remember. Number 6, the plaintiff was employed by my husband as an interpreter. She is now using the word interpreter. Number 7, the plaintiff was paid 10% of the work completed by him as his salary. Number 8, I do not know as to whether the said money was redistributed to non-major workers by the plaintiff or not. Number 9, the said non-major workers were paid salary to the plaintiff, but I do not know the total salary paid to such non-major workers. Number 10, I do not know the number of non-major workers engaged during the said construction work. Number 11, I do not know the exact time when the said construction of work was completed. Number 12, I do not know the time when the plaintiff was terminated from the work. Number 13, I do not know the work details of such a construction of work stated in the plaint. Number 13, I do not know as to whether the workers were served daily food during the said construction of work. Number 15, during said construction of work, we were residing at Singapore, Aizawl, Mizoram during that time. I was never working outside Aizawl. However, I worked in at South Indian Bank so-and-so during that time. It is a fact that I'm not depositing falsely. So the reason why I'm just reading out is that, Your Lordship, in fact, yes, she is a witness, but she has no any personal knowledge as to the communication about the plaintiff and the defendant, Your Lordship. And the work itself was also commenced prior to her getting married with the appellant, Your Lordship. And for that, Your Lordship, I must say that, yes, my learned friend also cited some crucial rulings stating that burden of proof lies upon the plaintiff. Yes, in fact, the burden was in fact proof by way of examination in chief, by way of oral testimony, Your Lordship. For that, Your Lordship, I must refer the Evidence Act specified at page section 59, Your Lordship. Lordship. I'm reading, Lordship.
59. Yes.
59. Proof of facts by oral evidence. All facts except the contents of documents or electronic records may be proved by oral evidence. I proved the facts by oral evidence because I was the one who actually do the construction work, and my two witnesses are actually who in touch about the construction, Lordship. And section 60, Lordship. Oral evidence must be direct. Oral evidence must, in all cases, whatever be direct, that is to say, number one is relevant, Lordship. If it refers to a fact which could be seen, it must be the evidence of a witness who says he saw it. The following paragraphs are not relevant in my case.
These things, it depends from case to case.
Lordship.
Supposing it is a dispute regarding property,
Lordship.
then it's applicable, oral evidence, very much. But in such a case, in the present case, where transaction of money and all that is concerned, how can the court come to a conclusion? How can the court decide unless something is there?
Lordship.
You know, not just oral evidence. And even if it's oral evidence, somebody who had witnessed or somebody who had been there during the transactions and who knew how much was given, how much was left, how much was due, that is also a different matter. That also could have been proved true of oral evidence. But in the present case, your witnesses also, they never knew anything about the contract between you and the defendant. They didn't know anything. They don't even know for sure whether you are a subcontractor or whether you are a manager. That also, because they are just laborers. How
That's
will they
true,
know?
Your Lordship. The reason why I'm just mentioning is that, Your Lordship, there is also a dispute as to how much percentage of the work was completed, Your Lordship.
That is also
Yes,
there.
Lordship. For that, I'm using this particular provision, Lordship. And regarding that quantum, that quantity of amount, that you see that amount, I'm saying that, Your Lordship, there was.
Because you're quoting a certain amount, he's also quoting a certain amount.
Lordship. Yes. For that, Your Lordship,
Yes.
I'm repeating that for that particular point. I'm repeating that, Your Lordship. The whole agreement, as per my version, as per my evidence, was 1.5 crore.
Yes,
But,
you
Your
said
Lordship,
that, yes, in
yes,
your deposition.
that is what I said. It's corroborated with the evidence of the defendant. Why? Because the defendant said that the work, keeping in mind the quantity of steel in tons, he said, and that's reflected in paragraph. Yes, yes, 1.48 crore. Lordship. That's quite corroboration, Your Lordship. So it is a fact that, Your Lordship, on perusal of the whole evidence, the defendant, in fact, trying to make some planted evidence regarding my position as interpreter or a manager, Your Lordship, or regarding the actual construction undertaken by me, Your Lordship. They are trying to make some planted evidence, Your Lordship. So keeping in mind all such particular circumstances, Your Lordship, it is somehow corroborated with what had been stated in their evidence. And the next important thing is that, Your Lordship, they said they paid some money in excess. Let's not be confused with the second construction. It's quite different, Your Lordship. For the second construction, I received 3 lakhs, Your Lordship. For the first construction, actually, they paid in excess about rupees 5 lakhs, Your Lordship. That's never claimed back by the defendant, Lordship. And, Lordship, even presuming Lordship, even presuming but not admitting that the actual work undertook by me was a sum of rupees 96,39,774.57 as per page number 31, 32, 55. That's in the evidence. I work 91.81 ton multiplied by 1,04,997. That comes rupees 96,39,774. That's there in page number 31 and 32, Lordship.
Yes.
That's quite relevant, Lordship.
96, yes, 96 lakhs 39,774.
Lordship. So, Lordship, as clear from what had been given in the examination in chief, the value of the work was rupees 96 lakhs, Lordship, presuming but not admitting, Lordship. If 96 lakhs amount of work was constructed, my salary would be 10% of the work completed, Lordship, as per the defendant. If 10% of 96 lakhs was taken into considered, it must be, Lordship, rupees 9,63,977, Lordship. If their statement, if their deposition is found to be true, my salary would be 10% of the work.
10% of 96
something lakhs.
96 lakhs.
Yes. But they mistakenly stated that I was paid in excess by rupees 5 lakhs. That's quite amazing, Lordship. And in fact, if I am to get my salary 10% of the work, I still has to get another rupees 4 lakhs, Lordship, basing on their statement, Lordship. Basing on their statement, Lordship.
How?
Meaning that, Lordship,
basing on this 96 lakhs 39,000.
Yes, 96 lakhs, 10% of 96 lakhs is rupees 9 lakhs point something. You got my point, Lordship? In page number 32, I'm repeating, para 3, clause F.
Yes, yes.
It is specified that the whole
The value of all the work.
amount was rupees 96 lakhs, Lordship. And 10% of the work amount completed by the plaintiff would be my remuneration. If 10% is
But
to be
during cross also you did not raise anything about this. Is there anything in the cross examination
Lordship,
about the amount?
for the particular point, Lordship, as it was not,
Because this is the whole dispute. This is the crux.
but Lordship, yes, I said that even presuming, I said, Lordship, that is not found to be true. The reason why I'm just making some hypothesis is that, Lordship, the whole examination in chief, in fact, has no relevancy with this particular point. As Your Lordship, I said in my examination in chief, I clearly stated with some other witnesses that I completed 99.9% of the work, and the agreed money was rupees 1.5 crore, and which is in fact corroborated to the total work calculated by the defendant, Your Lordship. And the reason why I'm just pointing this particular page number 32 is that even if presuming but not admitting, that's still in contradictory, Your Lordship. The reason why I'm just mentioning is that that is a good evidence for proving the contradictory statement of the defendant. If 10% is to be my salary, actually, Your Lordship, I'm not admitting this particular point. That's why it's not even raised in the cross-examination. But, Your Lordship, the reason is that even if it is found to be true, 10%, for the 10%, 4 lakhs is still due against the defendant, Your Lordship.
But even your contention of that agreement, 1.5, that is also disputed by them.
Lordship.
They are saying that that was never the agreement.
Lordship. That's why, Lordship.
And that is not proved by any of the PWs.
Lordship, exactly.
Because no one was there.
It's only between the
It's
plaintiff
only
and
between the two of them.
That's very difficult, Your Lordship. It's only two parties. No voice record in the particular point, Your Lordship. Unfortunately, the voice record which I annexed was the later part of the construction.
There
Your Lordship.
also nothing is there about the amount.
Lordship, yes, that's the termination only.
Yes.
The termination part.
Yes.
So, Your Lordship, my humble submissions, to conclude, Your Lordship, my humble submission is that, basing on the two sides, evidence is available for the two sides. My examination in chief regarding rupees 1.5 lakhs, no, 1.5 crores was kept intact. It was not in cross-examined, as no effective cross-examination was there. And, Your Lordship, their evidences about the quantity of the work done, in fact, is supported my submissions to 1.5. If the defendant, if the appellant is paying me rupees 1.5 crore, he still has to get a profit of rupees 72 lakhs, Your Lordship. As all the construction materials were acquired through me, and rupees 1 crore point something was in fact actually paid to some other seller, Your Lordship, some other agent for the steel works. And I have in fact no benefit at all. Now my benefit is kept in pending before the appellant, Your Lordship. And, Your Lordship, regarding the particular point as to the effective cross-examination, I must refer one judgment, 2016. Volume 12, SEC 288. Paragraph 15. I'm reading, Lordship.
Yes.
It's only so good.
Yes.
Moreover, there was no effective cross-examination made on the plaintiff's witnesses with respect to factum of execution of sale deed. PW1 and True have not been cross-examined as to factum of execution of sale deed. They were not cross-examined on that point. The cross-examination is a matter of substance, not of procedure. One is required to put one's own version in cross-examination of opponent. The effect of non-cross-examination is that the statement of witnesses has not been disputed. The effect of non-cross-examining the witnesses has been considered by this court in so and so. This court repealed the submissions on the ground that the same was not put either to the witnesses or suggested before the courts below. Party is required to put his version to the witness. If no such questions are put in the court, the court would presume that the witness's account has been accepted as held in so and so. So, Lordship, to conclude, I must say that the witnesses produced by the appellant hearing, DW 2 and 3 were properly cross-examined as to their relevancy to the case, and regarding DW1 also, Your Lordship, he was properly cross-examined, but Your Lordship, that particular point regarding that 96 lakhs so and so, actually he was failed to be cross-examined in that particular point, Your Lordship. But still, even that is to be counted as proper evidence. That shows the contradictory statement of the defendant. Why? Because there is an excess of rupees 5 lakhs. If I'm to get 10% of my work, I'm still have to get another 4 lakhs, Your Lordship. And the reason which I would like to stress upon this particular point is that there was, in fact, basing on the evidences, no point to interfere with the decision of the learned trial court. So, Your Lordship, my humble prayer for the conclusion is to kindly dismiss this bill. Lordship.
Yes. Yes.
My lords, regarding that figure of 2 crores 22 lakhs,
Yes.
he had said it in page 2 of his plaint. He had stated that amount. In para 4, we have categorically denied it. Just want to, my lords, clarify that. Second is, my lords,
Para 4 for WS.
yes, my lords, this is at page 31. Category behind that particular government legal. At para 3, sorry, at para 3, 31, page 31. Contents of para 4 of the plate are false and strongly objected. Their para 4 is at page 2.
Dear paragraph 4. For a total cost of 2.22 lakhs. Okay.
We deny it.
Mm.
This is all I'm saying. My lords, lastly, I just want to, my lords,
One
shortly
minute,
put.
uh, Then according to you, what was the value of the contract work?
1 crore 48 lakhs, my lords, which we put in page 31. The lordships are page 31. Page 31, my lords.
Hmm.
At para 3, sub-para B, my lords.
And that the quoted, this one, that the quoted rate of work
Was
No, no.
calculated in terms of ton and rupees per ton. And whole
The
work
work
was estimated
estimated
at
at-
141 ton, which is worth 148.
Okay, okay. 148,99,074.
The amount they executed is that for which they were, my lords, engaged is in paras, sub-paras. 100 ton, 100.157 ton.
It's the one crore 48 lakhs 99,074.
Which comes to about 1 crore 5 lakhs. As my learned friend had said. My lords, I just want to say one thing in rebuttal.
Mm.
At the end of the day, these calculations are an independent, my lords, field altogether. I say this because, my lords, today the suit is decreed to the effect that I have to pay him this much, $100, 10 rupees, whatever it may be.
Mm.
He has to show that how is even 1 rupee due and payable to him. That is all. We might say 96 here, 1 crore so and so, my lords, 2 crores. He just has to, my lord, satisfy that. We have also not disproved his case. We have not disproved, but it is a case which he has not proved. So,
Being the plaintiff.
yes, yes, he should have put better evidence, rather some evidence, my lords, to show that it was payable. Because all a plaintiff would need is, my lord, statements that he owes me this much. Then every suit would be decreed, my lords. That is the issue with this judgment, if it were to be upheld.
Mm.
And my lords, this judgment, if your lordships renders,
Mm.
your lordships, in a specific case where, my lords, there are so many terms between two people, contracting for whatever purpose, the terms of those contracts, my lords, if it's not put in writing, it is almost impossible to prove those terms, unless there are witnesses, as your lordship said.
Mm.
That-
That's why I'm saying
Yes.
it may be a verbal contract, but there should have been some people, who were present. But in this case, nobody was there. Mm.
So that is it, my lords. I conclude with that.
Okay, and then your rulings, have you given copies to the?
My lord, I have.
Okay, you have supplied
The compartment.
those.
I've already given my record. It's
These. Okay. Give only 3. Okay.
my lords, I had called for the books.
Okay. Give photocopies, not the whole book. Just give me photocopies of these judgments which is good. So number 1, then number 3. One will be this 2018 for GLT
Yes.
733. Then one will be AIR 2006 SC 1971. Then 2017 9 SCC 586. Okay. Third learned counsel for the appellant, Mr. Jordan Romintanga, also heard your name, Lung Siama, learned counsel for the respondent. Stop hearing is concluded. Judgment reserved.
Grateful, ma'am.
Yes.